Okay, hello sa inyo. Let us continue with the discussion with the remaining parts of Chapter 3 ng Obligation and Contracts. Start tayo sa Alternative Obligation. So, Section 3, Alternative Obligation, according to Article 1199, a person alternatively bound by different prestations, ibig sabihin, kung anong mga pinag-usapan nila, stipulations, the things to do in the contract, di ba? Shall completely perform one of them. Now, the creditor cannot be compelled to receive part of one and part of the other undertaking. So, eto, Section 3 na tayo. Pinag-usapan natin is yung different, another kind of obligation, which is alternative obligation. Kasi, alternative obligation, titingnan mo palang alternative, ibig sabihin, may choices ka, may options ka. Di ba? So, dito, kinds of obligations according to object, yun, simple obligation, ito yung napagdaanan natin sa mga previous examples, kung saan sa simple obligation, one where there is only one prestation. Ibig sabihin, isang undertaking lang yung kailangan gawin ni debtor. Ngayon, example dito, D oblige himself to deliver C a piano. O yun, iba-isa lang, to deliver the piano to C, isang prestation lang. D promise to repair the car of C, isang prestation lang. Repair the car of C. Ngayon, may tinatawag rin tayong compound obligation. One where there are two or more prestations. Ibig sabihin, dito na. Mas nagiging complex na kasi hindi na single prestation eh. Dalawa na, two or more na. Ngayon, may dalawang klase yan. From the knowledge set, no? So, since maraming options, since maraming obligation, paano ang performance yan, sir? May dalawa tayong types para dyan. Si conjunctive at si distributive. Ngayon, ito yung si conjunctive, one where there are several prestations. So, maraming undertakings na kailangan gawin. Si debtor, na kung saan lahat are due. Ibig sabihin, lahat kailangan niyang gawin. So, yan sa conjunctive. Ngayon, pagdating sa distributive obligation, ito na. Yes, mayroon tayong two or more prestations. However, iisa lang. Sa distributive, two or more of the prestations is due. It may be either, ito na. Ito yung lalabas sa mga board exam. Alternative or facultative. Si alternative, yes, there are several prestations that are due. However, the performance of isa lang sa kanila, isa sa mga prestations, goods ka na. It is sufficient. Yan si alternative obligation. Yes, there are several prestations. Yes, there are several that are due. However, the performance is one, goods ka na. Extinguish agad yung obligation mo once you perform one of them. Facultative, there's only one prestation. Wala, sir. One prestation lang. Paano naging, Paano naging, Paano naging compound obligation yan? Take note. There is one prestation. But the debtor may substitute another. So, ibig sabihin, meron tayong principal, meron tayong pang-substitute doon. Meron tayong primary, meron tayong secondary. Yung primary, yun yung main prestation. However, the debtor has the choice or the option para i-substitute yung main prestation. No, paano ang mechanics yan? Later on. Ngayon, meaning of alternative obligation. An alternative obligation, sabi dito sa book, is one wherein various prestations are due but the performance of one of them is sufficient as determined by the choice of which, as a general rule, automatic general rule, pagdating sa alternative obligation, di ba? Ang sabi natin, isa lang ang gawin mo dyan, goods ka na. Ngayon, papaano ang mechanics ng pagpili sa alin doon sa several prestations? General rule, kay debtor ang choice. Si debtor ang may choice. So sir, since general rule yan, may exceptions? Oo, may exceptions tayo, dalawa. Either si creditor, if expressly binigay sa kanya, or sa isang third party na kung saan there's a common agreement. Ibig sabihin, lahat nag-agree na ibibigay yung choice kay third party. Ibig sabihin, kahit si third party, dapat mag-agree din na siya yung may choice. Kasi wala nga naman, basta-basta na ilapag sa kanya na, uy, ikaw may choice obligation na to without asking the consent of that third party, di ba? So ito, example dito ng alternative. D borrowed from C, 10,000 pesos. So ngayon, ito sa grid, na itong si D would comply with this obligation by giving C 10,000 pesos or a color television set or pangatlong prestation, painting the house of C. So several prestations. So the performance of one of these several prestations, goods na si C. Goods na si debtor. Yun kasi ang nature ng alternative obligation. No? Let's go to Article 1200. The right of choice belongs to the debtor. General rule yan. Unless it has been expressly granted to the creditor. Yun na. Yun yung exception. Pangalawang exception. The debtor shall have no right to choose those prestations which are impossible, unlawful, or which could not have been the object of the obligation. So itong second paragraph ni Article 1200 basically talks about the limitation of choice. Siyempre, hindi yan absolute na may hindi absolute yan yung right ni debtor over choosing. But rather, may limitations yan para to avoid abuse, di ba? So ito, general rule, the right of choice kay debtor. So if the problem is silent, automatic si debtor yung may choice. Ngayon, by way of exception, it may be exercised by the creditor but only when it is expressly, tandaan nyo, expressly granted. Kung hindi expressly granted, impliedly granted, okay, etsapwera nyo yan. Don't consider that. Dapat expressly granted kay creditor yung choice. Sir, what's the logic behind that? Kasi tingnan mo, sino ang may burden sa isang obligation? Yeah? Si debtor. So at least bigyan mo naman sa kanya yung choice, di ba? Yung the right to choose, di ba? Kasi siya ang may burden siya ang may gagawin. So kaya maganda na siya yung may choice na kung ano yung gusto niyang burden na gawin. Kasi burden na ngayon at the first place, pahirap. Ngayon, kaya sinabi dito, stricto pagdating sa giving the creditor a choice kasi si creditor magbe-benefit Tapos siya pa yung pipili, medyo na yan Di ba? Medyo na. So kaya dapat expressly granted. Kailangan klaro. Another way is by a third person, another exception, by a third person when the right is given to him by common agreement. Big sabihin, all parties have agreed that the third person shall have the right to choose. Consent ang tawag niya. So, right of choice of debtor not absolute. Gaya na sabi ng second paragraph ni Article 1200. The debtor cannot choose those prestations, gaya na sabi, yung mga imposible, yung mga labag sa batas, unlawful, and yung which could not have been the object of the obligations. Bakit? Kasi those obligations or those prestations, are considered void. Ngayon, if, gaya na sabi natin, di ba, sa isang alternative obligation, there are several prestations. Now, the presence of one of these void prestations does not necessarily mean that the other prestations are also void. Hindi ganon. Hindi niya hinahawaan ng virus yung ibang prestations. Sa kanya lang, siya lang yung void. If the other prestations are valid, okay, they can still be chosen. Tanggal lang yung mga void prestations. Tandaan yan. Itong si void prestations, it does not necessarily mean that the other valid prestations madadamay. Hindi. Tanggal lang yung void prestations, the valid ones will remain. Ngayon, the debtor has no more right of choice when among the prestations whereby he is alternatively bound, only one is practicable. Like example, may tatlo kang options or may tatlo kang prestations to choose, debtor ka. Yung dalawa doon, void yung isa imposible, yung isang unlawful. So, alangan, piliin mo yung dalawa. Hindi mo pwede piliin yun. So, tatanggalin yung dalawang void prestations. Yung natitira, isa. Yung natitirang valid na isa. Yun na lang. And from that, automatic, HTFM, yung alternative obligation mo, will be converted to a simple obligation. Ganyan nangyari, di ba? Pag may alternative obligation ka, like so, debtor ka, may alternative obligation ka. The moment you choose one of those prestations, automatic simple obligation na siya. Kasi wala na eh. Wala nang several prestations eh. Hindi na sa pwede ko tawagin na compound obligation or compound alternative obligation. Yeah? Kasi isang prestation lang ang titira eh. And same din dito ang logic. When there are 3 prestations, 2 of them are void because the one is unlawful, the other is impossible. The remaining one, yun na lang ang matitira. And since that is one prestation with no other substitute, so hindi siya pwede maging facultative, magiging simple obligation na lang yan. Ito, mga examples natin. So, pag sa imposible, S promise to deliver to B 10 sacks of rice or a bowl of rice, starch, or soil from Jupiter. So, hindi naman pwede makadeliver ng soil from Jupiter. So, it is physically impossible. So, tanggal yan. Void prestation. Unlawful. Ito rin, pag yung isa sa mga prestations was kilo of dangerous drugs. Yeah? The other is parcel of land. The other is 2 carat diamond or 2 kill C na yung dangerous drugs pati yung kill C prestation, tanggal yan. Void yan eh. So yung dalawang remaining, si parcel of land and si carat, okay, stay yan sila. Ito, could not have been agreed. Same. Only one prestation is practicable. Basically, it begins to be simple obligation. Take note, as stated sa Article 1189, the debtor cannot choose part of the one prestation and part of another prestation. Oo. He cannot choose. He cannot compel the creditor. Na sir, if that's the case, pwede ba? Oo, pwede. Ang nakalagay lang dito, he cannot choose, he cannot compel, but he can persuade the creditor. Pag pumayag si creditor, okay, goods, walang problema. Pero you cannot compel the creditor. Hindi mo siya pwedeng pilitin. Persuade? Oo. Pag pumayag, okay, goods, good for you. Pero kapag hindi siya pumayag, gusto niya yung isa lang talaga, hindi na siya gusto niya isa talaga. Pag hindi siya pumayag na, part, hindi mo siya pwedeng pilitin basically. So, let's go to Article 1201. So, the choice shall produce no effect except from the time it has been communicated. Ano meaning yan? In layman's term, basically, pag hindi nalaman ng other party, and walang notice sa kanya about the choice or about the option you've chosen, it is not valid. Kailangan aware siya, hindi yung pwedeng isipin mo lang, okay, yung option to ang pipiliin ko, yung second prestation. Okay, yun na, matik, HTP, hindi ganun. Kailangan notified yung other party. So sabi dito, communication of notice that choice has been made. Effect of notice until the choice is made and communicated, the obligation remains to be alternative. O, kailangan communicated, kailangan notified yan yung other party. Kundi, hindi yan magiging simple obligation, alternative pa rin yan. O, once the notice of election has been given to the creditor, the obligation ceases to be alternative and becomes simple obligation. Such choice once properly made and communicated is irrevocable and cannot therefore be changed by other party without the consent of the other. So, ibig sabihin, pag sinabi mong, okay, prestation 1 ang gusto kong gawin, notified na si creditor. Ngayon, pwede mo bang, magbago isip ko, prestation 2 na lang. Automatic ba pag nagbago isip mo? Yun na, prestation 2 na agad? Hindi. Hingin mo muna yung consent ni creditor. Bakit, sir? Sabi ng batas eh. Kasi aware na si creditor eh. Okay, makaka-receive ako ng prestation 1, tapos bigla na lang magugulat na, bakit prestation 2 ang binigay mo sa akin, di ba? Bigyan mo ng notification. Then, pag nabigyan mo ng notification, nagbago isip mo, ask for the consent of the creditor. Para goods pa rin. Proof and form of notice, the burden of proving that such communication has been made is upon him who has made the choice. So, kung si debtor ang may choice, he needs to prove na, okay, pakita niya yung text nila na nag-reply si creditor o yung pinadala niyang mail, yung post or sa email, tapos may reply si creditor accepting that, di ba? The burden of proof lies with the person who made the choice and who communicated it. So let's go to Simple lang, di ba? Simple lang itong si alternative obligation. Ngayon, pagdating sa alternative obligation, ang pivotal point dito or prime factor dito na you need to consider is sino ang may choice? Sino ang may choice? Si creditor ba o si debtor? Sino ang may choice? Si creditor ba o si debtor? Kasi same na to sa mga sinasabi natin last time eh. Kung sino yung may choice, pinag-usapan natin sa thing, di ba? Mahalaga kung malaman mong generic siya or specific kasi iba yung mechanics ng dalawa. Same dito sa sa alternative obligation. Alamin mo sinong may choice, si debtor ba or si creditor kasi different mechanics din yan sila meron. So let's go to Article 1202. Thus, the debtor shall lose the right of choice when among the prestations whereby he is alternatively bound, only one is practicable. So nasabi natin kanina, di ba? Isa na lang yung practicable. Bakit? Kasi baka yung isa, yung isang prestation, tawag dito? Ganda ng cheetah. Oh. Yung isang prestation, naging unlawful kasi illegal drugs or patayin si C. Yung isa, naging impossible kasi kuha ka doon ng lupa sa Jupiter. Di ba? Yung isa, hindi part ng obligation. So yun. When only one is practicable, you have no right to choose kasi choosing means you have two or more option. When you only have one option remaining, there's no choosing in that sense, di ba? Kasi you are now complied to do that remaining practicable prestation. Now, let's go to Article 1203. If through the Creditors Act, the debtor cannot make a choice according to the terms of the obligation, the latter may rescind the contract with damages. So ito, loko-loko si creditor daw dito. Bakit? Because of creditor, si debtor, which has the right of choice in this case, cannot make a choice. Kasi para nag-intervene si creditor baka may ginawang kalokohan. So if that's the case, then may option si debtor. He can rescind the contract with damages. Tandaan nyo, pag sinasabi ang word na may, may, ibig sabihin, he can do that, he may do that, but it does not necessarily mean na he should do that. Binigyan lang siya ng option, may. Ha? Wala lang, baka maraming ganyan sa law questions, yung mga may, should, will. Take note of that. Kasi it changes the dynamics of the situation pag mga ganong situation. So, when debtor cannot rescind contract, rescission, it is basically one of the extinguishment of contracts. Kasi tingnan nyo sa book nyo, punta kayo sa contracts part, di ba? Sa part 2, sa contracts. Saan yun? Title 2, contracts. Meron dyan, saan dito? Sa last part, kinds of defective contracts. Yan, rescissible contract. Oh. Yan, ito, pagdating sa contracts, itong defective contracts, ito yung mga, pinupoint out ay, lungguman, di ay ko, Itong defective contracts, yan yung basically yung main tinatanong pagdating sa contracts, yung mga defective contracts. Oh. Kasi fun yan sila. But anyways, second quarter pa naman yan. Balik tayo sa alternative. So rescission is one of the rescission is one of the options na meron si debtor in this situation. Rescission basically, kung explain natin yan sa simpleng tao, cancellation of the contract because again, rescission creates the obligation to return the things which were the object of the contract together with their fruits and the price with its interest. With their price, with their fruits and the price with interest. So, balikan na rescission kasi cancel din contract. Another term is cancellation of the contract. So, in its very nature, replay natin. In its very nature of it is the very nature of an alternative obligation that the debtor cannot make his choice without the consent of the creditor. It is the very nature of an alternative loan that the debtor can make his choice without the consent. Oo. Pag si debtor ang may choice, concurrence, agreement of the creditor to that choice is not necessary. Nakalagay naman dito sa previous page eh. Hindi kailangan. Pag sinabi ni ni debtor na, oy, prestation 1 gusto kong gawin. Hindi pwede sabihin ni creditor na, oy, hindi, gusto ko prestation 2. Hindi. Bakit? Kasi in this case, the right of choice belongs to the debtor. Ngayon, pagdating kung ang right of choice na kay creditor naman, yun na. Pwede na hindi pwede kumanta si debtor. Kasi kay creditor yung right of choice eh. Pero in this case, since yung debtor yung may right of choice, hindi rin pwedeng kumontra si creditor. Because, kaya nga sasabi natin the right of choice is the deciding factor when it comes to alternative obligation because kung sino may choice, debtor, creditor, the dynamics, the mechanics between the two is different. Hence, the right given to the debtor to rescind the contract and recover its damages, if through the creditor's fault, he cannot make a choice according to the terms of the obligation. But take note, gaya na sabi natin, yung phrasing na may rescind the contract with damages, it is only an option. The debtor is not bound to rescind. Rescinding the contract, canceling it, is only an option. Oo, hindi bound si debtor to rescind the contract. So ito, example tayo. D borrowed from C 10,000 pesos. It was agreed that instead of 10,000 pesos, D could deliver item 1, 2, or 3. So may prestation 1, 2, or 3. However, may nangyari. Because of C, or because of the creditor, item 1, prestation 1, hindi na pwedeng gawin because item 1 was destroyed. So, in this case, D chooses to rescind the contract. Now, in case of precision, amount of 10,000 must be returned by D with interest. C in turn must pay D the value of item plus damages. The value of item 1 plus damages. Kasi item 1 considering it is assumed na it is with D eh. Tapos because of that, nasira. May ginawang kalokohan si creditor. Damages. Kasi di ba? Kikita niyo yung option dito. Yung una, pinili ni debtor na pinili ni debtor na i-rescind na lang yung kontrata, isauli niya yung 10,000 pesos, and with that, magbabayad ng damages sa kanya si C. Kasi may ginawang kalokohan si C eh. Bad faith siya, guilty party. Ngayon, take note ulit, gaya na sabi natin kanina, the right to rescind is not mandatory for the debtor to choose. It is only an option. Now, if the debtor chooses not to rescind the contract, now what will happen? Ito, third paragraph. D, instead of rescinding the contract, may choose item 2 or item 3 with the right to recover the value of item 1 with damages. So yun, if D chooses item 1, his obligation is extinguished, C is not liable for damages. Oh my God. Sir, shocking man yung last sentence. Pwede niya pa palang piliin yung item 1 kahit na nasira na? Oo. Pwede niyang piliin. However, pag pinili yan, C is not liable for damages. Bakit, sir? Parang yun parang siya na mismo yung nagpatawad kay C by choosing item 1. O isipin ni debtor, ay, okay. Since nasira naman to, and okay na sa akin siguro na piliin ko tong item 1 para wala na tayong problema. Bayad na ako sa utang ko sa'yo. Parang mga simpleng logic, simpleng reasoning lang ba? Okay na, para hindi na ako mahirapan sa pag-prepare ng item 2 and item 3, eto na lang item 1 para quits na tayo agad-agad. Yung utang ko, patawarin mo na. Yung ginawa mo sa akin kalokohan sa item 1, patawarin ko na rin. Kaya sabi dito, si D may 4 na options. Una, to rescind the contract, return the 10,000 pesos with interest, while at the same time, C, the creditor, will pay the damages and the value of item 1. Yung second and third option ni debtor, he can choose item 2 with damages and yung value ni item 1 kasi nasira man nini, or he can choose item 3 with the value of item 1 with damages. Or, the fourth option, ewan ko bakit na gustong piliin yun, B chooses item 1, his obligation extinguished, C is not liable for damages. So yun, parang naging 4 yung option ni Dean. Yun. From the original 3 prestations, nadagdagan ng rescission option. So depende na yan. Because in this case, the right of choice na kay debtor. Now let's go to Article 1204. Ito na. 1204 talks about the creditor having the right to choose. The right of choice. Diba? The right to choose, the right of choice. Wordings. So, in that case, mag-change yung mechanics ng obligation. Kasi nga, pagdating sa alternative obligation, pangatong sabi ko na to, nakadepende kung sino may right of choice. So, sabi ni Article 1204, the creditor shall have a right to indemnify for damages when through the fault of the debtor, all the things which are alternatively the object of the obligation has been lost or have been lost, or the compliance of the obligation has become impossible. The indemnity shall be fixed, taking as a basis the value of the last thing which disappeared or that of the service which last became impossible. Damages other than the value of the last thing or service may also be awarded. So, effect of loss of objects of obligation, Article 1203 and 1204 apply when the right of choice belongs to the debtor. Under Article 1205, the creditor has the right to choose. So, ito, 1203, 1204, si debtor yung may right of choice, 1205, kay creditor na yung choice. So, saan ba dito? So, some of the objects, if some of the objects of the obligations have been lost or have been impossible, or have become impossible even through the fault of the debtor, take note, the latter, si debtor, will not be liable since, ito na, the debtor has the right to choose. Oo, as long as the obligation can still be performed. Kita nyo? Kahit na yung prestations 1. Sabihin natin may 3 prestations. Prestation 1, 2, 3. Kahit yung 2 prestations, kasalanan ni debtor, bakit nawala, bakit nasira, or bakit hindi na pwedeng i-perform, hindi siya liable. Kasi may natitira pa eh. Prestation 3. Kasi nga, siya yung may right of choice. Siya yung may right to choose. Now, pagdating sa isang example na kung saan si creditor na may right to choose, doon, mag-iiba na ang usapan. Kasi dito, some of the objects nawala, nasira, hindi na pwedeng gawing i-perform. Kahit na si debtor may kasalanan, walang pwedeng gawin si creditor. Bakit? Si debtor ang may right to choose. Pwede sabihin, sige, yung natitirang prestation 3 na lang yung gagawin ko. Kasi hindi ko naman pwede gawin yung prestation 1 and 2 kasi ginawa kong kalokohan, nasira, hindi na pwedeng gawin. May right to choose. Debtor. Hindi yan pwedeng habulin. Hindi siya magiging liable. Ngayon, paano pag all of the objects are lost? Ibig sabihin, wala na talagang performance on the part of the debtor. Kasi nga, lahat na ng prestations, whiz. If all of the items have been lost or have become impossible through the debtor's fault, then the creditor shall have the right to indemnify for damages since the obligation can no longer be complied with. Kasi, sa first example some of the prestations lang. Dito lahat nawala and through the fault of the debtor. Of course, if the cause of the loss is fortuitous event, the obligation is extinguished. Ngayon, ito ang mahalaga dito. Paano natin ito gagawin? So, pause natin itong si Rhinoceros. Window capture. Wait lang window capture. 3. Okay. So in this case, debtor ang may choice Okay. Si debtor ang may choice. debtor choice. Si debtor ang may choice. Ngayon, sabi natin, when some of the objects, ulitin lang natin, are lost, yung natitirang prestation, pwede na, yung mga, when some of the objects are lost, then, but, may mga prestations pa rin, or kahit isang prestation na lang natira, na pwedeng i-perform, then, debtor will not be liable. Oo, kasi may natitira pa eh. Pwede pa niya i-perform yung obligation considering that the choice of the prestation is his. However, paano pag all of the objects are lost? All of the objects are lost. When it is through the fault of the debtor, sabi natin prestation 1, 2, 3, 4. If all of them are lost due to his fault, oy, bakit ito nag-zoom? Whoa. Oh. All of them are lost due to his fault. Fault ni debtor. Then, pwede siyang habulin ni creditor. Pwede siyang habulin ni creditor. However, if all of them are lost due to a fortuitous event, kasi yung unang example, kasalanan ni debtor. However, pag fortuitous event yan, a valid fortuitous event, then, walang liability si debtor. Fortuitous eh. Like for example, lahat ng prestation, lahat ng object na isang warehouse, nasunog yung warehouse without the follow-up debtor. So bakit mo pa siya gagawing liable, di ba? Ngayon, ito take note. Ito yung mga tricky part pagdating dyan. For example, some of the objects are lost. Sabi natin meron tayong 3 prestation. Ngayon, tandaan nyo to. May tayong 3 prestation bago ang example to. Yung unang 2 prestation, nawala, hindi na pwede gawing i-perform because of the fault of debtor. So, ito na lang yung natira, goods. Ngayon, afterwards, due to our fortuitous event, fire, nawala, itong remaining prestation na to, na naging simple obligation, nasira, o hindi na ma-perform, because of a fortuitous event, without the fault of debtor, then the obligation extinguished, hindi siya pwedeng habulin ni creditor. Tandaan niya yan, ha? Yung una-una, may 3 prestations, original contract nila. Original pinag-usapan. However, yung first 2 nasira. Let's say, kasalanan ni debtor, bakit nasira? However, since the right of choice is na kay debtor, hindi siya magiging liable, di ba? So, the obligation now becomes a simple obligation. However, later on, yung itong remaining prestation na to becomes hindi na pwede ma-perform. Like for example, because of fortuitous event. Without the fault of debtor, fortuitous event. Ngayon, in that case, pwede ba siyang habulin ni creditor? Hindi. Kasi yung ito, naging simple obligation na lang and yung natitirang object nasira because of fortuitous event without the fault of debtor. So, the obligation extinguished, debtor is not liable. So, yun yung mga trick question pagdating sa mga ganyan. Yung una nasira, kasalanan ni debtor. So, naging simple obligation. However, itong remaining, nasira, nawala, pero hindi na kasalanan ni debtor. Hindi na siya maging liable. Kasi in this case, naging simple obligation na lang yan eh. Okay, take note of that. Wait lang. Okay. So, ngayon, let's go to the indemnity shall be fixed, taking as the basis the value of the last thing which disappeared, referring to obligations to gifts or that will service which thus become impossible. So, kahit na personal obligations, considering dito, hindi lang real obligations. In case of disagreement, it is incumbent upon the creditor to prove such value which of the thing which last disappeared or which service last became impossible. Other damages may also be awarded. But take note, pag tag dito, Ngayon, in this case, for example, tatlong prestation ulit. Ngayon, itong first prestation nawala without the fault of debtor for 327, sabihin natin. So, the obligation becomes a simple obligation with the remaining one prestation. Now, if this remaining prestation was lost or has become impossible to be performed due to the fault of debtor, then the debtor can be held liable kasi in this case, kahit it has already become a simple obligation and the loss of the thing or the non-performance of the prestation was due to his fault, then he can be held liable. So dito, take na, 3 questions lang. Tip lang to. Dito, di ba? Itong first 2, kasalanan ni debtor. Tapos, since the right of choice is his, wala, hindi siya magiging liable. Magiging single obligation na lang yan. Simple obligation na lang yan. With one prestation. Tapos itong remaining prestation, nawala. Not because of, hindi dahil sa kanyang kasalanan. Hindi siya magiging liable. Dito naman, yung first 2, nawala. Nasira. Impossible to be performed. But not because of his fault. So, the obligation now becomes simple obligation with the remaining prestation. However, this remaining prestation, hindi na pwedeng ma-perform because of the fault of debtor. Then the debtor can be held liable. So, tingnan nyo yung mga sunod-sunod nila. So, anyways, let's continue. So, ito, 1203, 1204 talks about or refers to the mechanics kapag si debtor yung may choice. Ngayon, pagdating sa 1205, ito na. Si creditor na yung may choice. So, mag-iba na ang mechanics dito. So, when the choice has been made expressly given to the creditor, the obligation shall cease to be an alternative from the day when the selection has been communicated to the debtor. Gaya na sabi din kanina. Dapat communicated Hindi yung basta naisip mo lang. Kailangan inform yung other party. And nakita niyo dito, communicated lang. Hindi sinabing need for approval, need for concurrence because hindi kailangan nun. As long as communicated, as long as notified yung other party, whether the choice is with the debtor or the creditor, hindi kailangan ng concurrence of the other party. You just need to notify them. Now, until then, the responsibility of the debtor shall be governed by the following rules. So, ito, sabi dito, before the creditor nominates or communicates or notifies his choice to the debtor, for the meantime, listed dito ano yung mga kanyang responsibilities. So, yung una, if one of the thing is lost through a fortuitous event, he shall perform the obligation by delivering that which the creditor should choose from among the remainder or that one which remains if only one subsists. Ito, loss dito. If the loss of one of the thing occurs through the fault of the debtor, dito, sa una, fortuitous event. Yung second, through the fault of the debtor, the creditor may claim any of those subsisting or the price of that which through the fault of the former has disappeared with the right to damages. Pangatlong responsibility, if all of the things are lost through the fault of the debtor, the choice by the creditor shall fall upon the price of any one of them, also with indemnity for damages. The same rule shall be applied to obligations to do or not to do in case one, some, or all the prestations should become impossible. So, last paragraph basically says, or repeating what we have said kanina, hindi lang to na-apply sa real obligation, yung obligation to give, but also sa personal obligations, the obligation to do or not to do. So, in alternative obligations, the right of choice is the rule belongs to the debtor. Nevertheless, debtor So, ito. Rules in case of loss before creditor has made a choice or for the meantime, yung responsibility debtor. When a thing is lost through a fortuitous event, ngayon, ito yung responsibility na meron si debtor. Okay. And some of the things that happen in that. Saan yun? Hirap talaga pag mouse gamit, no? Mag-sketch. So, ganito yan. when a thing is lost to a fortuitous event. So one or some of the take note dito si creditor yung my choice. Kasi iba ng dynamics yan pag kung sino may choice, diba? Gaya sabi natin kanina. Dito si creditor na may choice. So yung unang responsibility talks about when one of the things or some of the things are lost through a fortuitous event, basta hindi kasalanan ni debtor. So may several prestations tayo. Sabihin na natin na yung prestation 1 and 3 nasira, nawala, or cannot be performed through a fortuitous event, basta walang kasalanan si debtor. And in this case, si creditor my choice. Always remember that. Now, magiging liable ba si debtor for this loss? Hindi. Hindi siya magiging liable. Fortuitous event kaya nawala So, ang dehado dito, si creditor na lang. Kasi ang pipiliin niya, either prestations 2 or 3 na. Prestations 2 or 4 na lang. Kasi yan yung available Hindi niya pwedeng habulin si creditor si debtor for the loss of these 2. Kasi walang kasalanan si debtor So, in this case, ang dehado, si creditor. Kasi na-limit yung options niya On the second case, when one of the things lost is through the fault of debtor, yun, mag-iba ng usapan. Mag-iba ng usapan. Sabihin natin na, okay, same. Or in this case, ito na lang. Si 2 and 4, si prestations 2 and 4, through the fault of debtor, hindi na pwedeng ma-perform. Through the fault of debtor na to. Ngayon, anong pwedeng gawin ni C? Si C, okay. Pwede niya pa rin maging option yan lahat. Paano, sir? Sample. Pili niya prestation 1. Prestation 1, okay? Perform prestation 1 with damages na to. With damages na to. Kasi kasalanan ni debtor Kasalanan ni debtor. With damages na to. Ngayon, pagpipiliin niya si prestation 1 or 3, yun, with damages. So, sabi niyo, pwede niya pang piliin yung dalawa O, pwede niya piliin yan. Price equivalent ni 2 or ni 4 with damages. So, sabi ni creditor, okay, pipiliin ko yung option 2, yung prestation 2. So, price equivalent na lang ng prestation 2 with damages. Price equivalent na lang ng prestation 4 with damages. Yan. Dito sa walang kasalanan si debtor kasi fortuitous. Dito, may kasalanan na si debtor. Now, when all of the things are lost to debtor's fault, etong si creditor, option niya pa rin yan lahat. Oo. Pili siya. Price equivalent ni 1, price equivalent ni prestation 2, ni prestation 3, ni prestation 4, with damages. With damages. Pili siya isa dyan. And when all of the things are lost to fortuitous event, okay, wala nang kasalanan si debtor dyan. Lahat na wala sa fortuitous event. For example, isang warehouse lang yung objects. Tapos nasunog ang warehouse. Fortuitous event, walang involvement si debtor, extinguish ang obligation. Fortuitous event, walang kasalanan si debtor. Bakit mo paparusahan yung taong walang kasalanan, di ba? And this rule is also applicable to personal obligations, gaya na sabi natin. So, nag-iba ang dynamics, as you can see. Nag-iba ang dynamics. Dito si creditor na may choice. Dito si creditor na may choice. Yeah? Sa'yo may choice dito. So, kita nyo? Nag-iba. Pag sa'yo may choice, dito may kasalanan si debtor. Nawala yung iba dahil sa kanya. Ngayon, si creditor may choice dito. Pwede niyang habulin si debtor. Kasi, debtor, kasalanan mo. Kasalanan mo, kaya nawala yung So, may damages, kailangan kang ibayad, debtor, indemnity. Kasi because of your fault, na-limit yung option ni creditor. Na-limit yung option niya. So, you need to indemnify that with damages. Oo. Sir, may tanong ako, sir. Ito, sir. Itong example na to. Okay, may 4 na option si sir. May 4 na option si creditor. Na yung isa, sir, nawala. Hindi na pwede mag-i-perform through a fortuitous event. Ngayon, yung isa naman, nawala. Kasi, itong si debtor, kasalanan niya. So, na-combine, nag-mix. Yeah? Alam ko, yung iba sa inyo, iniisip nyo, what sir if yung isa, fortuitous yung isa dahil sa kasalanan ni debtor? Simple lang mechanics yan. Combine nyo lang yung concept nitong dalawa. In this case, kasi di ba dito, hindi na pwedeng piliin ni creditor to. So, pipili na lang siya yung pwedeng applicable without damages from debtor. Dito sa second concept, pwede pa rin piliin ni creditor yung mga prestations na nawala dahil sa kasalanan ni debtor with indemnity for damages for all. So, combine mong concept niya dito. Itong una, walang kasalanan ni debtor, ito, kasalanan ni debtor. So, in this case, ang mangyayari, hindi ito mapipili ni creditor, itong isa, mapipili ni creditor, price equivalent na lang nga. Hindi na yung actual item kasi nawala na eh. Price equivalent, ito mapipili din. Ngayon, pag pinili ito, either sa kanila, that is with damages. O, combine lang the concept. Debtor cannot be held liable for this one, so hindi siya pwedeng piliin ni creditor. Kasi fortuitous event to eh. However, in this case, kasalanan ni debtor, so pwede niyang piliin ni creditor, price equivalent nga lang. Yeah? So, nakita niyo, di ba? Dynamics ng alternative obligation kapag si debtor yung may choice or kapag si creditor na may choice. So, take note of that. Now, let's go to the second one, which is the facultative obligation. So, simple lang itong si facultative. Wait lang. So, 1206. When only one prestation has been agreed upon but the obligor may render another in substitution, the obligation is called facultative. Facultative ang tawag. May main ka, pero pwede kang pang-substitute. The loss or deterioration of the thing intended as substitute through the negligence of the obligor does not render him liable. So kahit na yung substitute na wala dahil sa'yo, hindi na pwedeng ma-perform, you cannot be held liable. However, but once the substitution has been made, the obligor is liable for the loss of the substitute on the account of his delay, negligence, or fraud. Take note of that. Wait lang, ayusin ko lang to. Erase. Erase ko muna tong blackboard. So may dalawa tayong may dalawang timeline. But take note, punta muna tayo sa meaning of facultative obligation. A facultative obligation is one where only one prestation has been agreed upon but the obligor may render another in substitution. In this case, tandaan nyo, yung substitution, choice ni debtor. Hindi yan mapupunta kay creditor. Never yan mapupunta kay creditor. Sa alternative, pwedeng mapunta kay creditor or sa third person. Pero pagdating sa facultative, hindi yan pwedeng mapunta kay creditor. Walang ganong provision yung batas natin. Now sir, if that's the case sir, absolutely hindi pwede maging primary yung substitute. Pwede kapag kinausap ni creditor si debtor na, pinarsuade niya, di ba? Hindi niya pwede compel. Pero pwede niya i-persuade na, yung substitute na lang yung mo sa akin, sabi ni creditor kay debtor. Pwede yun. But he cannot compel. Okay? Persuade, kasi kailangan ng yung choice talaga is na kay debtor So, pwede niyang sige na, ganun di ba? So, ito, my example, I will give you my piano, but I may give my LCD television as a substitute. So, yung pagbigay ng piano yung primary obligation, the primary prestation, then yung LCD yung substitute, di ba? Now, take note, ito lang. Effect of loss. Ito na, saan dito? Okay, effect of loss. Ito, may timeline yan dito. Effect of loss. Itong linya na to, ito yung institution of substitution. Nag-substitute ka na dito. Wala lang, visual aid lang. Charot lang. Ito, nag-substitute ka na dito. Ito yung timeline. Ngayon, before substitute, Substitute. Kulang pa pala. Before substitution, kapag nawala yung sinubstitute mo, not ka liable. Not liable. Before substitution, you're not liable. Oo. Kapag nawala yung primary, okay, liable ka. Pero kapag nawala yung substitute, not ka liable. Wala kang kasalanan doon. Yung principal thing nawala, wala kang kasalanan. Yung substitute nawala, nabaliktad tayo. Yung principal, basta dito before substitution, nawala yung nawala yung principal thing, you are liable. Kasi yun pala yun yung main option eh. Pero kapag yung substitute ang nawala, not ka liable. However, when there's substitution, ibig sabihin yung substitute na yung ginawa mong primary. Tapos nawala mo yun, liable ka. Nawala mo yun, liable ka. Ngayon, after substitution, yung primary yung nawala. After sa substitution na to, hindi ka na liable. Kasi sinubstitute mo na pinalitan mo na. Oo, may bago na. Masakit, no? Ayun, di ba? Wala lang, tip ko lang magawa ng timeline. So, ganun. Okay, take note ulit Repeat lang natin. Before substitution, nawala yung primary. Nawala yung primary through a fortuitous event, not ka-liable. Nawala yung primary thing, liable ka. Liable ka. When it comes to the substitute, nawala yung substitute, may kasalanan ka man nawala, not ka-liable. Substitute pa rin siya Substitute pa rin siya. Ngayon, after substitution, yung primary thing, mawala man yan, kasalanan mo hindi ka magiging liable. Bakit? Kasi naging substitute na Ngayon, yung na-substitute, nawala dahil kasalanan mo, liable ka. On the other hand, kapag nawala yan because of fortuitous event, wala kang kasalanan, not ka liable. So, tingnan mo, after substitution, mag-iiba yan. After substitution. Kasi wala na sinubstitute mo na pinalitan mo na yung primary Di ba? Ito, last part is about the differences between alternative and facultative. Ito, about substitute lang to. So, alternative and facultative obligations distinguish number of prestations in the first. Sa alternative, several prestations but compliance of one is sufficient. Sa facultative, isa lang ang prestation that is due. Pero may substitute ka. Choice ni debtor. Right of choice, sa alternative, general rule, debtor my choice. Exception, when the choice is expressly given to creditor or when it was given to a third party through a common agreement, meaning lahat ng parties, in that case, nag-agree. Pagdating sa facultative, wala Debtor lang yung may choice. Kung gusto niyang i-substitute yung primary or hindi. Loss through a fortuitous event. In the first, loss of one of the alternatives. Ito, napag-usapan natin to. Loss through fault of debtor. Okay na. So yan, alternative obligation. Wow. Almost 1 hour's alternative. Wow. So anyways, continue natin to. Section 4. Ano ba matitira dito? Section, different kinds of obligation, joint and solidary, divisible, and obligation with the penal clause. Penal. So anyways, okay. Punta tayo sa next. Section 4, joint and solidary obligations. Ngayon, dito naman tayo sa section 4 ng chapter 3. Section 4 talks about joint and solidary obligation. Now, itong joint and solidary obligation, it basically talks about a situation in which there's plurality in a contract, in an obligation. There's a plurality, meaning there's two or more debtors and or two or more creditor sa isang obligation. So yan, joint and solidary talks about the plurality of the parties in an obligation. Ngayon, 1207 talks about solidary obligation, 1208 talks about joint obligation. So basahin natin 1207. So the concurrence of two or more creditors or two or more debtors in one and the same obligation does not imply that each one of the former has a right to demand or that each one of the latter is bound to render entire compliance with the prestation. May tinatawag tayong solidary liability only when the obligation expressly so states or when the law or the nature of the obligation requires solidarity. So yan, gaya na sabi natin, 1207, solidary obligation, 1208, if from the law or the nature or the wording of the obligation to which the preceding article refers, the contrary does not appear, the credit or debt shall be presumed to be divided into as many equal shares as there are creditors or debtors. The credits of debts or debts being considered distinct from one another, subject to the rules of court governing the multiplicity of suits. So yan sabi natin kanina. As you can see, 1207, solidary obligation, 1208, joint obligation. Section 4 talks about, ulitin natin, paulit-ulit, diba? Talks about the plurality of the parties. Ngayon, there are two kinds of obligation according to the number of parties. May tinatawag tayong una, individual obligation, kung saan meron lang isang obligor or isang obligee, isang debtor or isang creditor. Ngayon, the other kind of obligation in accordance to the number of parties is yung tinatawag natin collective obligation, kung saan there are two or more debtors and two or more creditors. So yan, two or more debtors, two or more creditors. Plurality of the parties, di ba? Plurality of the parties, di ba? Then, under collective obligation, there are two. Yung sinabi natin kanina, si joint at si solidary. Now, it is very important for you to distinguish between joint and solidary obligation because the same sa pinag-usapan natin sa alternative obligations, pagdating sa joint and solidary, iba rin yung dynamics yan, iba rin yung complexities nila, yung mechanics ng obligations na to. So joint obligation or one, the whole obligation is to be paid or fulfilled proportionately by the different debtors and or to be demanded proportionately by the different creditors. Each debt, basically meaning dyan, each debt is distinct and independent from each other. Ibig sabihin may separation yan. Paano explanation yan? Ito, punta tayo sa post natin si Monkey. Ito. Ganito yan kasimple ang isang joint obligation. Plurality. Sabi natin, there are three debtors. Sabi natin, ito sila, debtors to sila. Si D1, debtors to sila. And ito yung mga creditors. Creditors yan sila. Wait, may insekto sa screen. Please. Ay, joke. Kala ko insekto. Kala ko nasira yung screen niya. So, yan. Ito, debtor 1, 2, 3. Debtor. Ito naman, creditor. So, yan, may plurality tayo ng parties. Ngayon, pagdating sa isang joint obligation, let's say, 9,000 yung obligation. 9,000 na may utang si debtor, itong mga debtors kay creditor in the amount of 9,000. Ang sabi sa isang joint obligation, proportionately yung utang ni debtor and yung pwedeng ma-demand ni creditor proportionately lang. Meaning, kahit na 9K to, hatian sila proportionately or nakadepende sa kung anong usapan nila. Like sabi nila 2.5, tapos sa kanya 4K. Pero ang assumption, proportionately yung hatian nila. 3K sabi natin in this case. Ngayon, in the same case, sa creditor, proportionately lang. Assumption natin, equal shares in. Or kapag sa sa kasunduan nila, 2.5, 4K, pwede rin. Depende na sa kasunduan nila. Kasi pagdating sa joint and solidary obligation cash, ang tinitingnan dyan is not the prestation, but rather the obligations of the party. Yun yung focus dyan. Kahit na yung prestation is divisible or indivisible, hindi yan ang tinitingnan dito. Ang tinitingnan dito is obligation. ng mga parties. Kung joint ba yan or solidary. Kung ano yung gagawin nila. So in this case, we're talking about joint obligation. Meaning lang nito, si debtor 1, ang kanyang obligation, 3K lang. Debtor 2, 3K lang. Debtor 3, 3K lang. Yan lang yung kanilang duties. Ang bayaran yung kanilang proportionate part. Anything more than that, wala, hindi sila pwedeng habulin. 3K lang yung pwedeng habulin sa kanila. Yan si joint obligation. When it comes to the point of view of debtor. Pagdating sa creditor, okay, yan din. Proportionately lang ang kanilang pwedeng ma-demand. Proportionately lang yung kanilang right to receive. 3K. Si creditor 1, 3K lang ma-receive. Creditor 2, 3K lang. Creditor 3, 3K lang. Ganyan ang isang joint obligation. Napaka-simple. Di ba? Ngayon, pagdating sa isang solidary obligation, ito yung nakakainis. Hindi man nakakainis, mas complicated kasi solidary. Itong si solidary obligation, or one where each one of the debtor is bound to render and or each one of the creditors has the right to demand from any of the debtors the entire compliance of the obligation, the entire compliance of the prestation. Important words dito, each and entire whole or entire whole. Ano meaning yan, sir? Ganito ang, saan yung pen? I have a pen. Ito si debtor. Ito, pag nag-usapan natin ito, isang Ito si creditor. Ngayon, ito ang point of view dyan. Sabi natin ulit, may tatlong creditors, may tatlong debtors. 1, 2, 3. Ngayon, ganito na yan ang mangyayari. Hindi na sila liable for their individual parts kasi ang view dito is they are considered as one. Basically, yan yung solidary obligation. Paano word siya? Solidary, di ba? Solidary, meaning, in layman's term, pagkakaisa, di ba? Pagkakaisa. So, in this case, sa solidary obligation, ang tingin na yan sa kanila, as one. As one na. So, gaya na sabi ito, each of the debtor is bound to comply with the obligation. Each of the creditor has the right to demand from any of the debtor the entire compliance of the obligation, of the prestation. So kahit ang isa sa kanila, sabi ni creditor 1, gawin nyo tong obligation. Ngayon, in this case, yung pusa. Pusa ba? In this case, sabi ito yung 9K ulit. In this case, sabi ni creditor 1, kayong mga debtor, gawin nyo na tong obligation na to. Perform this. He can demand for the entire 9K. Di ba? He can demand for the entire 9K. Dito sa isa, he can only demand kung ano yung share niya. Oo, si creditor 2, yun lang. He can only demand his share. Creditor 3, he can only demand his share from the 9K. Dito naman, si debtor, they're only liable. Their only duties provide for the 9K. Provide for the 3K. Kasi yan lang yung share nila eh. Joint to eh. Joint. Lagay yung joint. Baka manis. Joint obligation to eh. JO. Oo. So, pag 3K yan, edi ang bayad niya, 1K, 1K, 1K. Ito, 1K, 1K, 1K. Kasi 3K eh. And ito, 1K, 1K, 1K. So yan yung obligation nila. Yung proportionate share lang nila. Pagdating sa isang solidary obligation, solidary obligation, itong si creditor 1, pwede niyang i-demand sa entire sa kanila, kayong mga debtor, fulfill your obligation. Or kahit sa isa, kahit sa itong si creditor 1, lapitan niya lang si debtor 1, sana yung 9K, pwedeng gawin yun ni creditor 1. He can demand for the fulfillment of the entire obligation. Or lapitan niya si debtor 2, sabihin creditor 1 or debtor 2, bayaran niyo na yung 9K sa amin. Yun, pwede niyang gawin. Entire obligation ang pwede niyang i-demand, hindi lang yung kanyang share. Yun yung essence ng isang solidary obligation. Now, let's say for example, punta naman tayo sa point of view ni debtor. Si debtor itong siya, no? Debtor 3, binayaran yung 9K. Buong buo. Extinguish na ba yung obligation? Pwede niya ba yung gawin? Oo, pwede niya yung gawin. Bakit? Solidary obligation yan eh. Solidary obligation, ang essence yan, the debtors is bound. Each one of them is bound for the fulfillment of the entire obligation. Each one of them is bound to the fulfillment of the entire obligation. So, pwede, required talaga siya magbayad ng 9K. Oo, kasi sila, each one of them, entire obligation, hindi lang yung kanilang share, entire obligation yung kanilang liability. They're liable for the entire obligation. Ito naman, dito, gaya na sabi din kanina, each creditor has the right to demand the fulfillment of the entire obligation. Hindi lang ng kanilang share. The entire obligation itself. The entire 9K in this case. So yan ang difference ni joint obligation. Na anong observe nyo? Mas bet si joint, di ba? Mas bet si joint. Kasi kung ano lang yung share mo, yun lang yung babayaran mo. Nga? Burdens. Ang solidary obligation napaka-burdensome kasi pati yung utang ng ibang co-debtors mo, babayaran mo. Liable ka doon. Solidary obligation, napaka-burdensome. Ito. Collective obligation. Ngayon, saan ba dito? So, there are many debts as there are debtors. There are many credits as there are creditors kasi each one of them, and the debts and or credits are considered distinct and separate. To joint obligation to. There are as many debts as there are debtors kasi ito. Obligation kasi there are many debts as there are debtors kasi obligation niya 3K. So, since there are 3 debtors, there are 3 obligations kasi each of them is liable for their share, di ba? Next, there are as many credits as there are creditors. Bakit? Creditors, di ba? 3 silang creditor. And they are entitled. They have the right to demand for their shares. Kung saan? 3 sila, hati sila. Next, the debts and or credits are considered distinct and separate from one another. Kasi joint obligation, they're only for the debtor, they're only liable for their share. Creditors, they are entitled, they can demand only for their share. Each debtor is liable only for a proportionate part of the debt. Ito, 3K, 3K, 3K. Each creditor is only entitled to a proportionate part of the credit. Joint obligation. Ito, words. Ito, mahalaga to. Words used to indicate joint liability. Natandaan ko pa to dito sa long quiz namin nung college. May namali ako dun isang number kung saan tinanong kung solidary or joint obligation. So, paano kayo namali? Ganyan. Other words used for joint obligation are mancomunada, to mga Latin to, pro rata share, proportionately share. We promise to pay, signed by the 2 or more persons. Another word na ginagamit is jointly and separately. Jointly and separately. Yung mga ginagamit, pro rata share, proportionately, jointly and separately. Ngayon, as said dito sa first paragraph dito sa 1207, as we have known, solidary obligations are burdensome. Napaka-burdensome kasi the debtors are liable for the entire obligation, di ba? So, ang sabi, if the problem is silent, always assume nyo joint obligation yan. Kasi mahirap i-assume yung solidary obligation because it is burdensome. Now, sabi sa 1207, there are only 3 instances where there's a solidary obligation. Una, when the obligation expressly states that it is a solidary obligation. Second, when the law requires it to be solidary. And third, the nature of the obligation requires solidarity. So yan lang, 3 instances. Expressly provided sa obligation, the law requires it, and the nature of obligation necessarily provides that it is a solidary obligation. When the problem is silent, assume nyo, joint yan. Ngayon, what are the words or phrases used to determine if it is solidary or if it is a solidary obligation? Provided naman ng book yan eh. Ito, example words. Minsan, ang madaling dyan, ginagamit A, B, and C are solidarily liable. O yun, expressly, di ba? Ito, jointly and or severally. Tandaan nyo, sa joint obligation, jointly and separately. Yan, ginagamit yan. Pagdating sa sa solidary obligation, jointly and severally. Ala sir, pampagulo man yan sir. Kala ko ba solidary obligation? Bakit may word na joint? Yun nga, pampagulo. Doon ako nagkamali. Kasi inassume ko, joint obligation, joint and severally. So inassume ko agad yung exam ko ng college. Since jointly and severally, okay, joint obligation yan. Sabi ko pa that time, dali man yan. Provided na ng problem. Yung pala, pag return paper, chicken. Jointly and severally, kahit na may word na jointly dyan, that is solidary obligation. Other words, solidaria, in solidum, together and or separately, or all together, individually and or collectively, juntos, separandi, a promise to pay signed by two or more persons. Yan mga words. So take note of the phrasing. Pero usually, sinasabi naman sa problem is, A, B, and C are solidarily liable to creditors E, F, G. Di ba mga ganun? Ngayon, there are two kinds of solidary obligation or solidarity. The first one is according to the parties bound. So, under sa according to the parties bound, tatlo. Passive solidarity or solidarity on the part of the debtors. Active solidarity, mga active passive parties. Active solidarity on the part of the creditors. And mixed solidarity kung saan meron tayong solidarity on the part of the debtors and creditors. So, meaning yan, anong meaning yan? I mean, passive solidarity, mga debtors lang yung solidarily liable. Active solidarity, yung mga creditors lang yung may solidary entitlement. Sa mixed solidarity, yun na. Both debtors and creditors are solidarily liable, solidarily entitled. No, simple lang yun, di ba? Tandaan nyo lang ang essence pagdating sa joint and solidarity. Sa joint, proportionate share. Ito, proportionate share. Uy, balik ko na sa mukha ko. Baka nami-miss nyo na mukha ko. Charot. So, yun, di ba? Sana tayo. Ano sasabi ko ulit? Basta tandaan nyo, sa joint, proportionate share ang pinag-uusapan. Proportionate share ng mga debtors, yun lang sila liable. Sa mga creditors, yung proportionate share nila, yun lang sila entitled to demand. Pagdating sa solidarity liable, debtors, they are liable for the fulfillment of the entire obligation. Sa mga creditors, they are entitled to demand the fulfillment of the entire obligation, not only their share. Diba? Now, the second kind of solidarity is according to source. Yun, conventional solidarity is the one that agreed by the parties. Legal solidarity, kung saan it is imposed by the law itself. Ito, marami tayong example. May mga examples naman dito. Those arising from crime. Yung mga principal accomplices accessories, they're solidarily liable. Ito, nakalist naman dito mga types of solidarity that arises from law. And real solidarity imposed by the nature of the obligation. So, ito sabi ulit dito, solidarity not imposed or not presumed, when the problem is silent, it is a joint obligation. Ngayon, let's go to 1209. Pagod. Sabi sa 1209, if the division is impossible, the right of the creditors may be prejudiced only by their collective acts, and the debt can be enforced only by proceeding against all the debtors. If one of the latter should be insolvent, the other shall not be liable for his share. So, 1209 talks about a joint indivisible obligation. Joint indivisible obligation. Ngayon, anong pinag-usapan nito? Ganito yung kasimple. Kasimple. Uy. Let's say kotse. Uy. Vroom, vroom. Car. So, meron tayong creditors A, B, and C. Ito, parang example sa book. So, sila ang debtors, si D ang creditor. Uy, ano yun? So, in this case kasi, sa isang joint indivisible obligation, it has both the characteristics of a joint obligation and a solidary obligation. Bakit joint indivisible? Ang pinapatangan ng joint part dito sa joint indivisible is that the obligation itself is joint. Ibig sabihin, the debtors are only liable for their share. The creditors are only entitled for their share. The debtors, ganun. It talks about the obligation. Now, yung indivisible part ng joint indivisible obligation, it already talks about the prestation. The prestation. Now, in this case, A, B, and C are liable or oblige themselves jointly to deliver this car to D. To deliver this car to D. Si debtor A, B, and C, they are jointly liable to deliver the car to D. Value daw to 40,000, di ba? To 40K. Ngayon, kotse yan. Hindi mo yan ma-chop-chop. Indivisible yan. Oo, definite yan eh. Indivisible. Alam si A, B, and C, hatiin nila yung kotse yan. Fita commercial, yeah? Hatiin, tapos kanya-kanyang delivery kay di. Hindi. Jointly liable sila when it comes to their obligation, when it comes to their share. However, the prestation talks about indivisibility of the object. Yeah? Kotse yan eh. I-deliver nila kay di, dapat buo yung pag-deliver nila. So, yun yung difference, di ba? Joint indivisible. Middle ground siya ni joint and solidary obligation. Kung saan yung obligation is joint. However, the performance of the prestation is indivisible. Kasi kotse to eh. Kotse to. Indivisible. Hindi ba pwede chop-chopin yan, di ba? Hindi na yung kotse pagdating kay di. Alangan, bigyan nyo pa ng hassle si di sa performance. Di ba? Sa pag-assemble niyan. Siyempre, when it comes to the obligation, the debtors are jointly liable. However, when it comes to the performance of the prestation, indivisible na yan. Kaya nga joint indivisible. Ngayon, gaya sabi dito, if C refuses to make his part, ayaw niya, tawag dito, ayaw niyang gawin yung parte niya sa performance obligation. Na, paano yan? Si NB hindi nila magagawa yung part nila. Kasi nga, yung performance yan, indivisible, kailangan sila lahat gawin yung kanilang parte. Since si C, ayaw niyang gawin yung part niya sa obligation, na walang magagawa si A and B kasi yung performance ng obligation is indivisible. So, paano yan? Now, in this case, si D, pwede niya silang habulin. Kasuhan sila. Ngayon, sir, di ba pag hahabulin na yun sila ni D? Pag magdidemand na yun si D? Di ba? May damages na yun, di ba, sir? Oo, may damages na yan. However, yung damages na yun, isisingil lang doon sa party na naging reason bakit nag-arise yung problema. In this case, that is C. So, C and B, since hindi na nila ma-perform yung car, let's say, yung delivery of car, so gagawin na lang nila is, babayaran na lang yung kanilang share sa value na 240K ng kotse. Babayaran na lang nila. So, 240 divided by 3 is 80. So, yun na. Babayaran nila ng 80 si D. Ngayon, ito si C, babayaran niya rin yung kanyang 80,000 na share dito sa 240k value ng car. Plus damages. Plus damages. Magiging liable rin si C for damages. Oo, magiging liable rin siya for damages. Bakit? Dahil sa kanya nagka-aberya eh. Nagka-aberya yung obligation. Masyadong pabebe, ayaw gawin yung kanyang parte. Ayaw gawin yung kanyang part. So with that, no choice si A and B. Kasi yung performance obligation, ulitin natin, is indivisible. Kailangan silang tatlo gawin yun. Eh, hindi man nila magawa niya tatlo. So, wala. Ano option si D? Habulin na lang sila for the price plus damages. Kung saan yung damages, pwede lang masingil. Ang magiging liable lang is yung party na naging reason bakit nangyari yung aberya at the first place. Ganun lang yung kasimple. So yan, joint indivisible obligation. Parang hybrid siya ng joint and solidary obligation. Yung obligation, yun yung joint, yung performance, yun yung solidary. May pagka-solidary because indivisible. So let's go to Article 12.10. The indivisibility of an obligation does not necessarily give rise to solidarity, nor does solidarity of itself imply indivisibility. Oh, just because the performance of obligation is indivisible, ibig sabihin kailangan one time, big time yung compliance, it does not necessarily mean that it is a solidary obligation. Why? Because what we're talking about when we discuss solidary obligation is not the performance of the obligation. It is not the performance, but rather the liability, the rights and duties of the parties in the face of the debtor. It is their duty to perform. They are liable for the performance of the entire obligation. We're talking about the rights and duties, the liabilities and entitlement of the parties. Sa debtor, yung duty nila to perform the entire obligation, they are liable for the entire obligation. In the eyes of the creditor, we're talking about the entitlement of the creditor for the entire obligation, their right to demand its fulfillment, the entire obligation, not only their proportionate share, but the entirety of the obligation. That is the sole concept of a solidary obligation. It is not in the performance itself, but the rights and duties, that entitlements and the liabilities of the parties in this case. Hence, when we say that the prestation, that the performance of the obligation requires or it is indivisible, it does not necessarily mean that it is a solidary obligation. Oo, hindi mo pwedeng i-assume yan agad-agad. Tingnan mo yung rights and duties, tingnan mo yung entitlements and liability ng debtors and creditors. Doon mo ma-determine if it is a solidary obligation. Kasi nakalagay dito, indivisibility refers to the prestation, while solidarity refers to the juridical or legal tie that binds the parties. In indivisible obligation, only the debtor guilty of the breach of obligation is liable for damages. While in solidary obligation, ito yung kawawa, burdens, ito yung kawawa pagdating sa solidary obligation. All of the debtors are liable for the breach of the obligation committed by one of their co-debtors. Bakit? Kasi they are liable for the entire obligation. So, kapag nagkaroon ng breach, liable silang lahat. Burdensome talaga si solidary obligation. Number 3, indivisibility can exist although there's only one debtor and one creditor. Kotse, di ba? Si A, bibigyan ng kotse si B, definite niyang object One time, big time performance. While in solidarity, there must be at least two debtors or two creditors because joint and solidary obligation talks about the plurality of the parties. And lastly, in indivisible obligations, the others are not liable in case of insolvency of one of the debtor. Pero pagdating sa isang solidary obligation, aba Diyos ko, the insolvency of one of the co-debtors shall be the burden of the other co-debtors. So pag yung isa mong kasama na insolvent, wala kang magagawa. Yung share niya, kailangan mong patungan. Kailangan mong ambagan. Kasi lahat kayo entitled sa fulfillment ng entire obligation. No choice kayo. Kaya nga burdensome talaga si solidarity. Kaya sabi natin, when the problem is silent, assume it is joint obligation because the nature of a solidarity obligation is burdensome. So, let's go to Article 12.11. Solidarity may exist even though, or although, the creditors and the debtors may not be bound in the same manner and by the same periods and conditions. So, kinds of obligation, according to legal tie, uniform where the parties are bound by the same stipulations, non-uniform or varied when the parties are not subject to the same stipulations. Ito, may mahabang example dito. Basta basically, example dito, si B, liable, ito, A, B, and C, A, B, C, and D oblige themselves solidarily to pay E 20,000 pesos as follows. Kung saan si A, to pay by installment at a date of 1,000 pesos a month to start in July, si B, to pay in September, C, to pay in December, and D, if E passes the CPA examination. Ngayon, kung babasahin niyo itong problems ito, basically, kahit sino man, basta na fulfill na yung conditions, basta na nag-arrive na yung period, basta nag-arise na yung obligation to pay, obligation to performance, kahit na it only pertains to a condition on one of the co-debtors, lahat ng co-debtors, liable pa rin dyan. As long as the right to demand, as long as the time to fulfill the obligation, yung conditions, pag dumating na yung period, lahat ng co-debtors na yan, kahit the problem only says si A, every month 1,000, basta nag-start na yung July, lahat yan sila liable. Kasi nga, solidarity obligation yan eh. Yun talaga, yun kasi yung essence ng solidarity liable. Kahit ano pang ek-ek mo dyan, kahit anong eche-eche mo dyan, ang essence ng solidarity obligation, rights and duties, entitlement and liabilities, as one yan, in its entirety. You are treated as if you're a single individual. Oo nga to. You're treated as if you're a single individual. Oo. Ganyan ang solidarity obligation. Marami pang ek-ek yan. Yan ang essence yan. Just understand the essence of a solidarity obligation, you're good to go. Let's go to Article 12.12. Each one of the solidarity creditors may do whatever may be useful to others but not anything which may be prejudicial to the latter. Like anong mga useful dyan? Yung mga beneficial act na useful sa co-creditors niya, di ba? Yung demand niya yung fulfillment, yung i-make sure niya na i-fulfill ng ng mga debtors yung obligation. Like for example, yung isang creditor nakita niya, mukhang i-defraud tayo ng ibang debtors natin So pwede siya mag-intervene doon para pigilan yung pag-defraud against sa kanila. That is an act beneficial to the all creditors, to his co-creditors. Pwede yung gawin. Beneficial yun Useful. However, he is prohibited to perform acts which may be prejudicial to his co-creditors. To his co-creditors. Like for example, remission or condonation of debts. Yung, di ba? Kinta ng kapitbahay na ito magpipip. Di ba? Ganito kasi nangyari pag remission or condonation. Remission or condonation of debt, basically, pinatawad mo yung utang. In layman's term, ganyan meaning yan. And it is one of the modes of extinguishment of obligation. Pag pinatawad mo yung utang ng example, pinatawad mo may utang sa yung kaibigan mo, pinatawad mo. Remission or condonation tawag doon. So pag pinatawad mo yung utang niya, wala extinguish ng obligation. Modes of extinguishment yan sa obligation, that is chapter 4 pa. Which is after ng ating discussion, di ba? Check ko ang table of contents. Chapter 4. Chapter 4. Chapter 4 ba? Yeah, chapter 4 mo. After ng discussion natin, after ng lecture video na to. So, isa sa mga modes of extinguishment na obligation. Ngayon, Since, di ba, ang usapan natin sa solidary obligation, liable for the entire obligation, entitled for the entire obligation. Each creditor is entitled for the entire obligation. Each debtor is liable for the entire obligation. So if creditor 1 remits or condones the obligation. Oo, kinondone niya. Ano mangyayari dyan? Then the entire obligation shall be extinguished. Oh, sabi niya sabi ni creditor 1 kay debtor 2, I condone the obligation na. Goods na yan. So yun, extinguish yung obligation. However, that is an act prejudicial to the other co-creditors. Kaya sabi nila, uy, bakit mo pinatawad yung utang na yan? Hala, Diyos ko, bakit mo yung ginawa? Wala na yung entire obligation. So in this case, pag yun na nangyari, etong co-creditors ni creditor 1, pwede, ang gagawin nila, since wala nang obligation, pinatawad niya Oo, niremit niya, kinondone niya. So, ang gagawin ng mga co-creditors dito, in this case, si creditor 1 na yung hahabulin nila. Kasi hindi nila ito pwede habulin Kasi yung ginawa ni creditor 1, yung condonation of the entire obligation, it is valid. Because he has the right to do that. Kasi nga, solidary obligation to. However, in this case, ang mangyayari, etong co-creditors, siya na yung hahabulin, si creditor 1. Bakit mo pinatawad yan? That condoning that obligation is prejudicial, sabi ng mga co-creditors. What the hell did you do? Condoning that obligation is a prejudicial act. It is not beneficial to us. So in that case, ang gagawin ng mga co-creditors, si creditor 1 yung hahabulin. Ganyan yan. So let's go to 1213. A solidary creditor cannot assign his rights without the consent of other co-creditors. He cannot assign the rights to third parties. Sa outside parties. Unless may consent ang other co-creditors. However, kapag yung assignment niya ng rights niya is to a co-creditor, okay, hindi na necessarily need pa ng consent ng other co-creditors. Ganyan lang yan. Why? Bakit? Anong reasoning behind that? Kasi kayo lang nandyan Bakit ka magpapasok ng third party? Kayo lang nandyan. Bakit? Ano bang assignment of rights, sir? Parang ganito. Ikaw at yung classmate mo may utang sa'yo. Yung classmate mo may utang sa'yo 1,000 pesos. Ngayon, ikaw na creditor, sabi mo, sige, I will assign my rights to that utang to your other classmate. So in that case, yung classmate mong may utang sa'yo, ibibigay na lang yung 1K sa other classmate nyo kasi inassign mo yung rights mo sa kanya over that utang. Same in this case, na instead yung ikaw yung directly makaka-receive ng benefit, inassign mo sa third parties or sa other party. Now, sabi ng 1213, you cannot do that unless may consent ka ng other creditors. Ngayon, if yung assignment of rights mo is with the other creditors, okay, goods lang. No need consent. So, 1214, the debtor may pay any one of the solidary creditors, but if any demand, judicial or extrajudicial, has been made by one of them, payment should be made on him. So, yung sabi natin, di ba? Each debtor is liable for the entire obligation. Each creditor is entitled for the entire obligation. So, if one of the debtors paid, sabi natin dito, si debtor 3, pinayaran si creditor 3, then goods, the entire obligation extinguished. However, if one of the debtors, if one of the creditors demanded payment, sabi natin si creditor 2, then since sa'yo nag-demand, required kang sa kanya i-remit yung payment. Required kang sa kanyang i-remit yung payment. Kasi siya yung nag-demand Yan lang siya sabi ni 1214. Pero pag walang nag-demand, pwede kahit sino sa kanila ang ibigay mo yung full payment ng 9K. Creditor 1, 2, or 3 man. Pero kapag tapos pag niremit mo na kahit sino sa kanila, extinguish ng entire obligation. However, if one of them demanded, let's say creditor 2 demanded it, then you are required to remit to him the payment. Kasi siya yung nag-demand Para wala nang confusion ba. Para diretso na sino nag-demand agad. Now, 12.15. Novation, compensation, novation, compensation, tawag dito, Article 12.15, novation, compensation, confusion or remission of debt made by any of the solidary creditors or with any of the solidary debtors shall extinguish the obligation without prejudice to the provisions of Article 12.19. Anong Article 12.19 ulit? Sa advancing. So itong may second paragraph pa pala. The creditor who may have executed any of this act as well as he who collects the debt shall be liable to the others for the share in the obligation corresponding to them. Ngayon itong novation, itong compensation, itong confusion or remission of the debt is mga modes of extinguishment yan ng obligation. So sa novation, ang nangyayari dyan, you have an old ito short explanation lang kasi chapter 4 pa naman to. Sa novation, ganyan, if you have an old contract, if you have a current contract, then kung gusto nyo baguhin yan, significant changes dyan, then okay, significant changes, boom. Wala na yung old contract. Out of that, will born a new or will arise a new contract. So parang binago nyo lang yung kontrata nyo. Yeah? Old contract, tinanggal nyo na. You made a new contract. That is novation. Compensation, confusion. Sa confusion naman, or merger, ganito ang example ng confusion or merger. Ganito yung itsura ng confusion or merger. Let's say ikaw to. You. Oy. Let's say this is you. Tapos ito mga tao to. And ikaw, may utang ka kay sa crush mo. Ngayon, itong crush mo, may utang dito sa kanya. Itong taong to. Na kung saan itong taong to, may utang rin sa taong to. Kung saan itong taong to, may utang rin sa taong to. Kung saan itong taong to, may utang din sa taong to. And itong taong to, may utang rin sa'yo. So yan yung tatawag nating confusion or merger. Where the personality of the debtor is the same as the personality of the creditor. Nag-combine. And that is you. So in that case, yung crush mo, wala nang utang sa'yo kasi nagpasa-pasahan na yan. So parang as if quits na kayo. Yan yung meaning ng confusion or merger. So remission, yan yung condonation pinag-ausapan natin kanina, yung pinatawad mo yung utang. So those are the modes of extinguishment. So sinasabi dito, balikan natin. Ay, joke. Hindi ko na-transfer yung Okay, balikan natin. So ganito yan ang ulitin ko lang. Sayang yung sinabi ko. Hindi ko pala na-change yung screen. So, ganito yan sa confusion or merger. This is you. Crush mo. Ikaw may utang ka sa crush mo. Crush mo may utang sa taong to. Itong taong to may utang sa another tao. Itong taong to may utang sa another tao. Kung saan itong taong to may utang sa another tao, kung saan itong taong to may utang sa'yo. So sa confusion or merger, the personality or the characteristics of a debtor and creditor napunta sa isang tao. So in this case, yung obligation between you and your crush, extinguished na yan. Kasi tiyan mo, circle. Parang circle of life. Parang naging quits na kayo in the end. Yan yung confusion or merger. So, the characteristics of a debtor and a creditor na combine sa isang tao. So, tama na. So, basically, itong And yung remission or condonation, gaya sabi natin, yung discuss natin kanina, pinatawad mo yung utang. Malay mo, kasi baka isa sa mga debtor is crush mo. So, pa-impress ka sa crush mo, pinatawad mo lang yung entire obligation. Now, in that case, anong mangyayari? Ito, nasabi naman natin. In that case, effects of novation. In that case, kapag ikaw ay nagpatawad, kasi ikaw, creditor 1, to nasabi natin kanina, ulitin natin. Ikaw, creditor 1, naging confusion or merger kayo with debtor 2. So, pag gano'n yung nangyari, entire obligation na yung nawala. Or depende sa amount. Let's say, same amount 3, 9K. So, in that case, the entire obligation is extinguished. Pero pag 7K lang yung confusion or merger nyo, di ba? So, 2K na lang yung natira. Pero pag buong 9K yung confusion or merger nyo, the entire obligation is extinguished. Ngayon, such happening is prejudicial to the rights of the other creditors. Bakit? Wala na silang marireceive eh. Kawawa naman. Kayong dalawa yung may utang dyan eh. Kayong dalawa yung may confusion or merger. Tapos bakit ito nadamay dalawa? So, since ito yung rights na prejudicial, ibig sabihin, hindi maganda yung naging effect sa kanila, naging negative yung effect sa kanila, ito sila, gaya na sabi din kanina, pwede lang habulin etong si creditor 1 for that prejudicial act. Ang habulin nila, based on their share, let's say, ang share nila is 3K din, then pwede nilang habulin si creditor 1 of 6K, each for their share. 3K sila, 3K si creditor 2, 3K si creditor 3. So, yan lang basically, parang same lang si sa sinabi natin kanina. Basta, pag ganyan nangyari, nagkaroon ng extinguishment without the participation of the other creditors. Kasi kawawa sila eh. Pero magulat na sila, bakit mo pinatawad yung utang? Bakit nagkaroon ng confusion of merger? Bakit may innovation? Ganun. So, pag na-extinguish na yung entire obligation, kung sino man yung creditor na may may kasalanan, or sabi natin may kasalanan, pwede siya yung habulin ng mga co-creditors for their share. So, in this case, 9K, so 3K sila. Itong si creditor 2 and creditor 3, hahabulin nila si creditor 1 for 6K. Let's go to 1216. The creditor may proceed against any one of the solidarity debtors or some or all of them simultaneously. The demand made against one of them shall not be an obstacle to those which may subsequently be directed against the other so long as the debt has not been fully collected. The right of creditor to proceed against any solidarity debtor. Sabi natin, pwedeng si creditor 1. Pwedeng si creditor 1, habulin niya si debtor 1, o si debtor 2, habulin niya, si debtor 3, habulin niya. Pwede yan. That is his right eh. Entitled, he is entitled for to demand the fulfillment of the entire obligation. And each of the debtor is liable for the fulfillment of the entire obligation. So, kahit sino sa kanila pwedeng mag-perform ng obligation, and once it is performed, then the entire obligation is already extinguished. Yan. So, 1217, payment made by one of the solidarity debtors extinguishes the obligation. Yun, kasi nga, ganyan, solidarity obligation yan eh. If two or more solidarity debtors offers to pay, the creditor can choose kung sino man sa dalawang nag-offer yung tatanggapin niya yung offer. Like for example, yung isa sa mga nag-offer, crush niya. Yun yung pipiliin niya para may moment sila ng crush niya. Second paragraph. He who made the payment may claim from his co-debtors only the share which corresponds to each with the interest or the payment already made. If the payment is made before the debt is due, no interest for the term being paid may be demanded. When one of the solidarity debtors cannot, because of his insolvency, reimburse his share to the debtor paying the obligation, such share shall be borne by all his co-debtors in proportion to the debt of each. So, ganito yan. Gawa ba tayo bagong Huwag na, ito na, same lang. So, ganyan sabi natin kanina, sino mang creditor can demand the fulfillment of the entire obligation. Sino mang debtor can perform the fulfillment of the entire obligation. Once nangyari yan, extinguish na yan. Ngayon, ito yung pinag-usapan in this case. Let's say debtor 3, lagyan lang natin numbers nila. let's say debtor 3. Sabi ni si debtor 3 ayaw niya na magkaroon ng utang sa life niya, di ba? Ayaw niya na magkaroon ng utang sa life niya. Saan nandito? Ayaw niya na magkaroon ng utang sa life niya. So, ayun yung makonsensya siya. Baka hindi siya makatulog kasi hindi siya sanay na may utang siya. So, si debtor 3, sabi niya, sige, babayaran ko na tong obligation na to. Itong buong 9K, babayaran ko na. Boom, okay. He can do that because this is a solidary obligation. So, yun, wala nang obligation. Extinguish na. However, since debtor 3 performed the obligation by himself, he is now entitled for reimbursement. So, pwede na siyang mag-demand ng reimbursement kay debtor 1 and 2 for their share. In this case, let's say it's proportionately. Pwede rin iba yung usapan nila. Like, 2.5K sa kanya 4K. Depende sa usapan nila. Or in this case, let's assume it's 3K each proportionately. So, in this case, si debtor 3 can now demand reimbursement from debtor 1 and 2 in the amount of 6K. 3K each sila. Kasi yung 3K siya naman, sa kanya naman yung siguro yun, di ba? So, he can demand the 3K kay debtor 1 and debtor 2. Sabi mo, debtor 1, debtor 2, yung ambag nyo, bigyan nyo na sa akin, nabayaran ko na yung utang, extinguish yung obligation natin. He can demand that. Yan na yun. Reimbursement yun. He is entitled to reimbursement. Now, in a scenario where where one of the solidary debtors is insolvent. So, pag insolvent siya, hindi niya mabayaran yung utang niya. Or hindi siya makaambag insolvent wala siya pang bayad. So, paano yung mangyayari dyan? Then, since this is a solidary obligation, sasaluhin yan ng mga co-debtors. Sasaluhin niya nila. Sasaluhin niya nila. So, since yung tatlo sila, 3K each sila, 3K each, okay. Saan yun? So, 3K each sila, 3K. Ngayon, yung mangyayari, since itong si debtor 2, hindi na makabayad, so, ang magiging liability ni debtor 1 and 3, kasi wala nang insolvency debtor 2 so, solidary obligation pa yan, madadagdagan ng 1.5K. Kawawa sila, di ba? Madadagdagan ng 1.5K. Bakit? Solidary obligation yan Kapag joint obligation yan, na insolvent si debtor 2, walang pake dyan si debtor 1 and 3 kapag joint obligation yan. Bakit? Kasi si debtor 1 and 3, ang pake lang nila is yung kanilang share na utang, which is 3K. Pag na-insolvent 2, wala to sila. Wala yan silang liability. They are not obliged to make ambag on the share of debtor 2 kapag joint obligation yan. So, in that case, yung magsasuffer is the creditor. Kasi kukulangin yung pambayad Kukulangin yung marireceive nila. So, habol yan nila sa utang, insolvency law. Pero different na yun. Pero ganun yung mangyari. Ngayon, pagdating sa solidary obligation, itong pinag-usapan natin ngayon, since each and every debtor is liable for the entire obligation. No choice sila pag na-insolvency debtor 2. Kailangan nilang mag-ambag sa share ni debtor 2. So yun, maghihintay na lang sila kung kailan hindi na insolvency debtor 2, tsaka sila pwedeng maningil. So ganyan sa solidary obligation. So, sana tayo? So, payment by a solidary debtor shall not entitle him to reimbursement from his co-debtors if such payment is made after the obligation as prescribed or become illegal. So, ano may ng prescribe? Prescribe in this manner talks about prescription. Prescription refers to the fact na kung saan rights and obligations are lost by prescription. A good example of that, ladies and gentlemen. Joke. A good example, So, Okay. So, a good example like, may lupa. May lupa kung saan may bakanting lupa. Tumira ka dyan. After 30 years, or depende sa facts and circumstances, either after 10 years, kapag clear title yan, or after 30 years, kapag hindi clear ang title ng lupa na yan, after 10 or 30 years, depende sa title sa lupa na yan, occupying that land, let's say, after 30 years, kapag mayroong nagmamayari sa lupa na yan, pero pag after 30 years of occupying that land without any disturbances, without any outside disturbances, parang hinayaan ka lang ng may-ari, ganun, di ba? Hindi kanya ginalaw, pinalis, o etc. After 30 years, magiging iyo ang lupa na yan. Generally, by prescription. After 30 years, so ikaw, occupying that land after 30 years, magiging sayo yan. Yung totoong may-ari niyan, after 30 years, since wala siyang ginalaw, hindi nagalaw yung lupa, knowing na nandyan ka nakatira, he will lose the right over that land. Ikaw, tumira ka dyan for 30 years without any disturbances, you will have the right over the land. So yeah, you will gain the right over the land. So yan yung prescription. Rights and actions are lost by prescription. By prescription, one acquires ownership and other rights through the lapse of time in the manner and under the conditions laid down by law. So that is an example, yung sa lupa. 30 years occupancy without any disturbances, magiging sa'yo ang lupa na yan. Pero pag may disturbances yun, mag-stop yung counting of time. So yan, by prescriptive period. So basically, ang meaning ng prescribe in this context is that it ends at the time that it ends. So, pinag-usapan sa Article 1218, payment by solidary debtor shall not entitle him to reimbursement from his co-debtors kapag yung payment na ginawa niya is made after the obligation as prescribed. Meaning, hindi ka na required magbayad kasi the obligation has already prescribed, the obligation has already end, pero nagbayad ka pa rin after that, you are not entitled for reimbursement. Kasi wala nang obligation per se eh. Hindi ka na required magbayad. Pero bakit mo pa rin binayaran? Loko-loko ka pala. Di ba? Parang ganun. So nga, pag nag-prescribe ng obligation or kapag the obligation itself become illegal, like for example, sabi natin dito, vape yung obligation, yung prestation. I mean, tapos, before the delivery, biglang ginawang illegal yung vape. So, in that sense, the obligation has already become illegal, so void na siya. Pero nag-deliver ka pa rin ng vape. Oo. Now, in that case, since the obligation has already become illegal, you cannot ask for reimbursement. Kasi illegal yung obligation eh. Bakit mo pa ginawa? Loko-loko ka pala. Or hindi mo pala ng but ignorance of the law excuses no one from compliance therewith, di ba? So, ganun lang sinasabi ng 1218. Kapag wala nang obligation to perform the obligation, di ba? Pag you are not obliged to perform the obligation, pero ginawa mo pa rin due to some reasons, di ba? You are not entitled to reimbursement. So, ikaw debtor, hindi ka pwedeng mag-demand ng reimbursement from your co-debtors pag ganun yung nangyari. So, Article 1219 talks about so, wala na naman to. Remission made by debt by creditor of the share. So, in this case, lagyan natin ang timeline. Sabi ng 1219, the remission made by the creditor of the share which affects one of the solidary debtors does not release the latter from his responsibility towards the co-debtors in case the debt has been totally paid by any one of them before the remission is effected. So, gawa natin ang timeline. Ito yung time. Bakit lagyan pa na? Ito yung time. Ito yung time na kung saan nagkaroon ng remission. Pinatawad ng isang debtor ay pinatawad ng creditor yung isang debtor. Ito naman, let's say this is the time of payment made. Ngayon, if ganito yung nangyari, nauna yung remission sa payment, okay, goods yun. Goods yun para sa isang debtor. Goods yun sa debtor. However, kapag opposite yung nangyari, payment yung nauna, then nagkaroon ng remission, ibig sabihin na comply ng obligation, then the co-debtor is still liable to the other co-debtor for his share. Hindi niya pwedeng takasan yun. Ganun lang sinasabi dito. Kasi, it is basically escaping yung obligation eh. Oo, nabayad na nga yung utang eh. Binayaran na yung utang. Tsaka pa magre-remission, ay hindi naman talaga pwede. Lugi kami. Lugi yung co-debtors mo. Dito lang invalid. Dito hindi na invalid. Kasi remission, okay, bawas na yung utang. So, tas doon ang payment, okay, goods yun. Pero dito nagkaroon na ng payment eh. Tsaka pa magkakaroon ng remission. Ala, Diyos ko, kawaw yung mga co-debtors mo. Yeah? So, 1220 talks about the remission of the whole obligation obtained by one of the solidary debtors does not entitle him reimbursement from his co-debtor. Simple. Oo. Parang sana yung example natin kayo. Saan may example natin kayo? Parang dito. Di ba? Parang dito. Sabi natin na itong si creditor 1, ni-remission niya yung dahil sa for example, crash niya si debtor 2. So, itong si creditor 1, ni-remission yung entire obligation. Ngayon, itong si debtor 2, kung saan sa'yo naging reason ng remission, hindi siya pwede mag-ask ng reimbursement from debtor 1 and 3. Bakit? Kasi pinatawad lang yung utang eh. Wala siyang ginawa on his part. Wala siyang nilabas na pera on his part. Wala siyang ginawang obligation on his part. So, bakit siya mag-ask for reimbursement? He is not entitled to any because he didn't do anything. Hindi sapat na reason na si creditor 1 crush niya lang si debtor 2 kaya niya ginawang remission. Hindi sapat na reason. Wala siyang ginawa on his part eh. On her part na siya kasi crush man. Yeah, walang ginawa on her part, on his or her part. So bakit siya mag-ask for reimbursement? He is not entitled to that. In that case, di ba, ganyan sabi natin kanina, on the creditor side naman, dito, si creditor 20, habulin niya pwede nilang habulin si creditor 1. Sabi, hoy, creditor 1, loko ka. Pinatawad mo yung utang kasi crush mo si debtor 2. Haba, loko-loko ka. Compensate mo kami. Reimburse mo kami. Dahil sa crush mo, in-extinguish mong obligation. Ganun. Sa debtor, walang pag-remission yan, condemnation, pinatawad yung utang. Hindi entitled for reimbursement. Pero pagdating sa creditor side, gaya na napag-usapan natin kanina, yun, habulyan nila ng co-creditors yung creditor na nag-initiate ng remission. Oo. See, that is prejudicial to their right. Ito, simple na lang tong So, 1221, if the thing has been lost or if the prestation has become impossible without the fault of the solidary debtors, the obligation shall be extinguished. So, yan simple lang. Di ba? Parang napag-usapan natin last time pa. Kasi basically they are treated as one eh. Di ba? Parang ganun yung point of view. Kasi each and every one of them is liable for the obligation. Sa creditors naman, each one of them is entitled for the obligation. So parang treated as one sila. So in this case, sabi ng paragraph 1, kapag yung the thing has been lost or the prestations become impossible, extinguish ng obligation as long as without the fault of the solidary debtors. Sabi naman sa paragraph 2, if there was a fault on the part of any one of them, all shall be responsible to the creditor or creditors for the price and the payment of damages and interest without prejudice to their action against the guilty or negligent debtor. So, ito nasabi natin kanina. Na-mention naman natin ito, ulitin na natin ngayon. Joint obligation, wala kang pake kung ano mang gawin ng ibang debtor. As long as gawin mo yung iyong share. Goods ka. Solidary obligation, kung ano man ang kalokohan na o nangyari sa sa other co-debtors mo, liable ka dyan. Pag nagkaroon ng insolvency, wala kang choice. Ambag, dadagdagan mo ang ambag mo. Kapag nagkaroon ng violation on one of them, wala ka ring choice. Magiging liable ka rin for damages. Bakit? Each and every creditor, each and every debtor is liable for the entire obligation. Liable for the entire obligation. So wala eh. Kahit ikaw yung innocent debtor, pero itong si debtor to loko-loko, wala kang choice. Liable ka rin sa ginawa niyang kalokohan. Third paragraph, if through a fortuitous event, the thing is lost or the performance has become impossible after one of the solidary debtors has incurred delay in through the judicial or extrajudicial demand upon him by the judicial debtor, the provisions of the preceding paragraph shall apply. So same lang. So 12.22, the last article sa joint and solidary obligation. A solidary debtor may in actions filed by the creditor avail himself of all the defenses which are derived from the nature of the obligation and of those which are personal to him or pertains to his own share with respect to those which personally belongs to the others. He may avail himself therefore thereof only as regards that part of the debt for which the latter are responsible. So, wala rin. Hindi naman ito importante. So, basically, solidary and joint obligation, it talks about the plurality of the parties and it talks about their entitlements and liabilities. It talks about their rights and duties. Yun yung pinag-usapan sa solidary and joint obligation. Hindi sa indivisibility o divisibility ng performance obligation. Hindi doon. Rights and duties ang tinitingnan natin. Yung juridical tie between them. And tandaan, it is very important to know the difference between the solidary obligation and a joint obligation. Bakit? Kasi iba yung mechanics silang dalawa. Yeah? So now, let's go to divisible and divisible obligation. Now, let's go to sa section 5, divisible and indivisible obligations. Sa itong divisible and indivisible obligations, napakasimpleng obligation lang to. Kahit hindi kailangan mag-in-depth discussion nito kasi napakasimple lang. Unlike sa solidary and joint, yun, medyo medyo complex yun eh. Pero pagdating to sa indivisible and divisible obligation, goods lang. So, kahit shortcut na tayo dito. Hindi naman to masyado yan sa board exam. Pagdating sa obligations, it's more on lalabas talaga yung solidary and jointly. Kaya sabi ko kanina. And yung extinguishment, yan. Extinguishment, dyan din yan. Mga tina-target sa board exam questions. Pero focus mo tayo dito sa section 5, okay? So, section 5, divisible and indivisible obligations. Article 12.23. So, divisibility and or indivisibility of the things that are the object of obligations in which there is only one debtor and only one creditor does not alter or modify the provisions of Chapter 2 of this title. So, basically, ang pinag-usapan natin dito is yung divisibility and divisible and indivisible obligations. Okay. Meaning of divisible and indivisible obligations. A divisible obligation is one of the object of which in its delivery or performance is capable of partial fulfillment. Kaya nga hence the word divisible, capable of partial fulfillment. An indivisible obligation is one the object of which, kung saan sa obligation na to, the delivery or performance of the object of the obligation is not capable of partial fulfillment. Now, test for the distinction. Ngayon, pagdating sa determination, if it's a divisible or indivisible obligations, hindi mo titingnan yung object. Don't look at the divisibility of the object. Sabi dito? Do not look on the possibility or impossibility of partial prestation. Meaning, don't look at the object of the obligation. Huwag mong tingnan kung pwede mo siyang partial fulfillment kasi divisible siya, or hindi siya pwedeng partial fulfillment because of its nature. Hindi yun yung controlling circumstances, hindi yan yung deciding factor. But rather, tingnan mo kung ano yung intention ng parties. Tingnan mo kung ano yung intention ng parties. Tingnan mo kung ano yung provided by law. Kasi di ba source of obligations ito yung law and contract of the parties. Tingnan mo kung ano yung sabi ng batas in regards to that obligation. Tingnan mo kung anong sabi ng parties, kung anong intention nila. Kung partial fulfillment ba? So indivisible obligation. Or hindi partial fulfillment, gusto nila one time, big time, then that is an indivisible obligation. Na sir, absolute rule ba yan? Hindi. Bakit? Kasi titingnan mo. If the object, if the prestation is not physically divisible or the service is not susceptible of partial performance, then automatic HTPM, it is absolute. It cannot be indivisible. I cannot be divisible. Indivisible yan. Kasi dito, ang tinitingnan mo na yung nature ng yung nature ng object, yung nature ng prestation. Oh, sir, parang medyo nakakahilong rule na yan, sir. Ganito lang kasimple. Sana yung ating handy-dandy sketchbook. So, ito lang, suggestion lang. Rule of thought, tingnan mo. Sir, sabi nyo, di ba, yung divisibility or indivisibility ng performance, ng prestation or object, hindi yan yung tinitingnan. Yan yung sabi ng book. Pero, para mas madali yung flow of thought, ito yung sa, ganito kayong tinitingnan. Ito, prestation, or yung object ng obligation. Tawag dito, capable of partial fulfillment. Paano isulat dito? Capable of partial fulfillment of partial not capable. Ay, mali. Mahirap talaga pag oopsie. Yun, di ba? Capable of partial fulfillment. Capable of partial. Dalawa yan. If yes, then check mo kung anong intention ng parties. If no, it is not capable of partial fulfillment. By its nature, it is not physically divisible. Yeah? No, automatic na yan, HTPM. Pero pag yes, then tingnan mo yung intention. O yung intention o yung provided ng batas. Intention or law. If sa party sabi nila hindi, okay, kahit na capable of partial fulfillment or not, pero intention ng party, pero yung sabi ng batas hindi, ganon yung performance, di indivisible obligation siya. Yeah? Yan. Parang flow of thought lang ba? So anyways, yan lang may mahalaga dyan eh. Madali lang man tong divisible and indivisible obligation. Kahit lang, yan lang. Yan lang yung discussion, walang problema tayo dito. Oo. Applicability of Rule 1223. Okay, mga examples dito. Punta tayo sa kinds of division. Mayroon tayong qualitative division. From the word itself, quality, quantitative, ideal or intellectual. So, hindi to problema ng divisible and indivisible. Most of the time, inaano nila ng mga lawyers dinadaanan lang. Ito lang yung discussion. Partial fulfillment of hinde. Legal indivisibility, conventional divisibility. Ito, madali lang, di ba? Dinadaanan lang natin. Ito, 1225. Ito, sige to. Article 1225 basically talks about obligations deemed indivisible or obligations deemed divisible. So, ito na yung mas malawak na discussion, di ba? So, mga obligations deemed indivisible, yung una, obligation to give definite things. Example, kotse, bahay. Mahirap naman yan siguro, electric pan. From the nature of the thing itself, di ba? Mahirap silang i-partial fulfillment. Wala nga sa kotse. Una mo muna ibigay yung gulong. Pangalawa, yung suspension. Then yung customer ang pabagawaan mo ng kotse. Hindi ganun. Pag definite thing yung usapan, it is an indivisible obligation. one-time, big-time fulfillment. Another, obligations which are not susceptible to partial fulfillment or partial performance, gaya ng pagkanta, pagsayaw, yeah? Obligations provided by law to be indivisible even if the thing is or service is physically divisible. Payment of taxes, ang bayad ng taxes hindi yan paunti-unti. General rule, hindi yan paunti-unti. One time, big time ang bayaran dyan. Sir, so kung general rule, side note lang sir, kung general rule ng payment of taxes is one time, big time, so may mga instances sir na pwede palang paunti-unti. Oo, pero sa ano na yan yan na yung pag hindi ka nakabayad ng tax, so pag bigyan ka nila ng payment plan, para makabayad ka lang, pero exception na yun. Sa remedies na yun sa taxation. Sa taxation pa yung malaman. Pero yun, fulfillment of tax liabilities, magbayad ka sa obligation sa gobyerno, one time, big time ang bayaran dyan. Bakit? Provided by law. Yung remedies na lang yung mga partial fulfillment yun, exceptions lang yun. Obligation, pangapat sa obligations deemed divisible, yung intention ng parties na kahit na physically divisible yung object, kahit na physically divisible yung prestation, yung service, pero yung intention ng parties, one time big time bayaran, one time big time performance, masusunod yung gusto ng parties. Ito naman, lastly, obligations deemed divisible. Obligations which have for their object the execution of a certain numbers of days of work. So ito, pag sinabi dito na you have 10 days to finish painting the house. Then you have divisible Pwede mong paunti-unti gawin yan basta within 10 days. Obligations which have for their object the accomplishment of work by metrical units. Yung 1.5 meters to make a table, 1.5 meters no obligation. Pangatlo, obligations which by their nature are susceptible of partial fulfillment. Ito, divisibility, and lastly, divisibility or indivisibility in obligations not to do, applicable pa rin yan. Okay. So, tiyan mo, dinaanan lang natin ang section 5. Kasi hindi masyadong problema itong o hindi talaga problema itong divisible and indivisible. Ito lang yung titingnan, yung partial ito lang yung titingnan. Tingnan mo yung object, tingnan mo yung prestation, tingnan mo yung service. It is capable of partial fulfillment. If it is a no, then automatic, indivisible obligation yan. Now, if it is capable of partial fulfillment, yes, now tingnan mo na. Ngayon, tingnan mo na kung ano yung intention ng parties, tingnan mo na kung ano yung provided by law. If the intention of the parties, if the law provides that even though it is capable of partial fulfillment, partial performance, pero yung intention nila is indivisible, masusunod yung gusto nila. Yun na, gano'n na yung kasimple. So, next tayo, last topic natin which is, anong last topic dito? Obligation with the penal. Penal clause. So, punta tayo sa last part ng discussion natin, section 6, obligation with the penal clause. So, start na tayo, okay? So, article 1226, ang sabi dito, in obligations with the penal clause, the penalty shall substitute the indemnity for damages and the payment of interest in case of non-compliance, if there is no stipulation to the contrary. Nevertheless, damages shall be paid if the obligor, si debtor to, refuses to pay the penalty or is guilty of fraud in the fulfillment of the obligation. The penalty may be enforced only when it is demandable in accordance with the provisions of this code. So, obligations to the penal clause. Basically, penal. Anong meaning yan? Basically, penal talks about the prescribing a punishment for an offense. So, pag may ginawa kang kasalanan, in this case, breach of the obligation or non-performance, non-compliance, papatungan ka ng kasalanan. Anong kasalanan ng punishment? Ngayon, before that, let's talk about meaning of principal and accessory obligations. Principal obligations, tandaan nyo to, one which can stand by itself and does not depend for its validity and existence upon another obligation. It can stand on itself. Oo. Accessory obligation on the other hand is attached to a principal obligation, therefore it cannot stand alone kasi nakadepende yung kanyang effectivity sa another obligation. It is attached to another obligation. Si principal, it can stand on its own. Now, this is an example of this is an obligation with a penal clause. Bakit? Kasi in an obligation of the penal clause, it is one which contains an accessory undertaking to pay a previously stipulated indemnity in case of breach of the principal prestation intended primarily to induce its fulfillment. So yan na, meron tayo yung sa obligation of the penal clause, merong principal, meron accessory. Yung principal obligation is yung kung ano yung prestation ng contract, ano yung kailangan yung gawin, ano yung object. Yun si principal obligation. On that, it can stand on its own. Yung accessory dyan is the penal clause. Yung punishment na pinag-usapan nyo, na stipulated, na kung saan if there's a non-compliance, if there's non-performance or a breach of the breach of contract, kumbaga, edi, tsaka napapasok si accessory obligation, the penal clause. Di ba? The penal clause. Kasi, penal clause nakadepende sa principal obligation eh. It is attached to the principal obligation. Na kung saan, yeah, it generally substitutes the payment for or indemnity for damages and legal interest. Yan yung buhay ng isang penal clause. Like for example, may utang ka sa classmate mo. Na kung saan, pinag-usapan nyo kapag hindi nagbayad ng utang or, example, ito na lang, may usapan kayo ng classmate mo na kung saan, gagawin mo yung assignment niya. Now, kapag hindi mo ginawa, tapos isa sa mga stipulations na pag-usapan nyo, kapag hindi mo ginawa yung assignment niya, babayaran mo siya ng 100 pesos. So in that case, ano yung principal obligation? Yung gagawin mo yung assignment ng classmate mo. Ano yung accessory? Yung kapag hindi mo ginawa yung assignment ng classmate mo, babayaran mo siya ng 100 pesos. That is the penal clause. That is the punishment laid down by your contract kung saan there's a breach or non-compliance on the part of the debtor. That is the penal clause. That is the accessory obligation. So, ganun yung penal clause eh. Instead of magkaroon ng payment for, indemnity for damages or legal interest, i-state yun na agad sa contract nyo, i-state yun na agad sa pinagkasunduan nyo kung ano yung magiging parusa. Diretso na. Yeah? Hindi na kailangan na mahabang usapan kung magkano yung damages. Kasi yan yung reason eh. Kaya tayo may obligation sa penal clause. Instead of pag-usapan pa, pagdebatihan pa magkano yung damages na babayaran, diretso na ilagay nyo sa contract magkano yung punishment. Di ba? Ganun na kasimple. Kasi mahabang proseso yan class yung pag-determine magkano yung damages plus yung interest na babayaran. Mahabang proseso yan. Pag-aawayan nyo pa yan. So, instead na pumunta kayo sa arduous process na yun, diretso na, sabihin nyo sa contract, o pag nagkaroon ng violation, boom, 100,000 ng payment. Yeah? Diretso na. Kaya mayroon tayong obligation to penal clause para diretso na. Efficient na, diretso na. Hindi na pag-aawayan pa magkano yung payment for damages. Ngayon, meaning of a penal clause is penal clause, sabi dito, is an accessory undertaking attached to an obligation to assume greater liability in case of breach or non-compliance. The obligation is not fulfilled or is partly or irregularly complied with. So yung tatlo, di ba? Tatlo yung types of breach. Non-compliance, part compliance, or irregular compliance. Yeah? So ito, sinabi dito, purposes of penal clause, dalawa. Reparation or deterrent. Second is punishment. Siyempre, una, sa deterrent o sa reparation, to ensure their performance by creating an effective deterrent. Panakot, kumbaga, against breach, making the consequences of such breach as onerous as may be possible. So, this is the general purpose of the penal clause. Panakot, pang-deterrent. Oo. In order to ensure that the obligor will perform his obligation. Oh, it is sure. Deterrent yan eh. Deterrent for non-compliance. Deterrent for breach. Panakot. The second one is to substitute for punishment. To substitute a penalty for the indemnity for damages and the payment of interest in case of non-compliance, or to punish the debtor for the non-fulfillment or violation of his obligation, para diretso na. Hindi na pag-uusapan pa, hindi na kayo pupunta sa korte para pag-awayan ano yung magiging punishment ni debtor. Diretso na, provide nyo na sa contract para hindi na mahaba yung usapan. Penal clause, distinguish kinds of penal clause as to origin, legal penal clause provided by law. conventional penal clause provided by stipulation of parties. Another kind is as to its purpose. Compensatory penal clause when the penalty takes the place of damages. Another one is punitive penal clause when the penalty is imposed merely as a punishment for breach. As to its demandability or effect. Another kind, under sa kanya, subsidiary or alternative penal clause when only the penalty can be enforced. Joint or cumulative penal clause when both the principal obligation and the penal clause can be enforced. When both the principal and the penal clause can be enforced. So yan, no? Oo, may mga instances na kung saan, 'di ba? Ang sabi dito is the penal clause is pamparusa para sa punishment para sa non-compliance, 'di ba? So may mga instances na kung saan pwede ka mag-demand ng fulfillment o mag-demand ka ng compliance, then at the same time may penal clause. So mga ganung instances. Pero may mga instances din na kapag nagkaroon ng breach, 'di ba? Nagkaroon ng breach, penal clause lang ang pwede mong hingiin, ang pwede mong i-demand. So, penalty substitutes for damages and interest. So, general rule, kapag when talking about obligation with the penal clause, the penalty takes the place of the indemnity for damages and the payment of interest in case there's a non-compliance, in case there's a breach. That is the general rule. So, kung may general rule, ano meaning yan? Meron tayong exceptions. Ano mga exceptions na yun? 3. When so stipulated by the parties, meaning nakalagay sa contract, apart from paying the penal damages provided, the penal clause. Sabi sa stipulate, expressly sinabi, payment for damages and legal interest shall also be complied with, yeah? So, on top of the penal clause, o penal damages, yeah, penalty, provided in the contract, magbabayad ka pa ng additional damages and interest when so stipulated with the party. Another exception to the general rule, when the obligor refuses to pay the penalty, in which case the creditor may recover legal interest thereon. So, yeah. So, required ka magbayad ng penalty on June 5. Kaso on June 5, hindi mo binayaran. So, hanggang hindi mo binabayaran, napapatungan yun ng interest, ng legal interest. Yeah? Habang di mo binabayaran as time pass by. So yun, pwede ka makarecover on top of the penalty. The third exception is when the obligor is guilty of fraud in the fulfillment of the obligation. So with that, in which case the creditor may recover damages caused by such fraud. So kung may fraud dyan, napatunayan na may fraud, okay. On top of the penalty, mayroon ka pa makaka-recover ng damages. So yun, no? General rule, the penalty substitutes the payment for damages, the indemnity for damages, and interest. General rule yun. Exceptions, 3. When it is stipulated by the party, when the obligor refuses to pay the penalty, so magpapatungan na yun ng legal interest. And the third one, when there is fraud. So, when penalty may be enforced, kailan mo ma-enforce yung penalty? When it is demandable in accordance to the civil code. So, kailan siya nagiging demandable? If there's a breach of the obligation and it is not contrary to peeps, law, morals, good customs, public order, and public policy. So, yan, demandable in accordance with the provisions of the civil code. Kailan siya nagiging demandable? When there's a breach of the contract, yeah, violation of tenor. And second, when it is not against peeps, law, morals, good customs, public order, public policy. So yan, dyan nagiging enforceable yung penalty. So 1227, the debtor cannot exempt himself from the performance of the obligation by paying the penalty, save in case where this right has been expressly reserved for him. Neither can the creditor demand the fulfillment of the obligation and the satisfaction of the penalty at the same time, unless this right has been clearly granted to him. However, if after the creditor has decided to require the fulfillment of the obligation, the performance thereof should become impossible without his fault, the penalty may be enforced. So, penalty not substitute for performance. So, gaya na sabi natin kanina. Kanina. Sa damages pala yun. Generally, the debtor cannot just pay the penalty instead of performing the obligation. Alangan sabihin niya na, ay, tinatamad akong gawin yung obligation ko, bayaran ko lang ang penalty. Generally, bawal yon. Hindi niya pwedeng gawin yon. Sabi niya, ay, tinatamad ako. Sige, penalty na lang bayaran ko diretso. Bawal yun, generally. Pero, if it is expressly, gaya ng sabi dito, if it is expressly reserved for him, pwede. Kapag expressly reserved for him. Pero kapag hindi niya pwede gawin yun. On the other hand, saan dito? On the other hand, kay creditor naman, general rule, the creditor cannot demand the fulfillment of the obligation and the satisfaction of the penalty at the same time. Hindi yun pwede. Like, nagkaroon ng breach. Yeah. Tapos sabihin niya na, oy, ikaw debtor, gawin mo tong, I'm compelling you or I'm demanding you to perform the obligation at the same time paying the penalty to me. Hindi niya pwedeng gawin yun. General rule, hindi niya pwedeng gawin yun. Pag may general rule, may exceptions. So, gaya na sabi dito, unless this right has been clearly granted to him, then pwede niyang gawin yun. And however, as another example, another exception, if after the creditor has decided to record the fulfillment of the obligation, tapos nagkaroon ng the performance thereof should become impossible without fault, the penalty may be enforced. So, dito na nakalagay. Kapag nagkaroon ng performance, once the obligation is fulfilled, this purpose is attained, and therefore, there's no need for demanding the penalty. Except when this right is granted or clearly, expressly, clearly granted to him, that there's no doubt in the stipulations of the contract. There's no doubt that such right of demanding the fulfillment and demanding the penalty at the same time, such right is clearly granted to the creditor. And in this case, balikan natin, it is not a subsidiary or alternative penal clause, but it is now a joint or cumulative penal clause. Kung saan, gaya sabi natin kanina, when both the principal obligation and the penal clause can be enforced. Kaya on the other hand, when there is no performance, then the creditor may ask for the penalty or require specific performance. Now, in this case, it is mutually exclusive, kumbaga. It is mutually exclusive. Meaning, iisa lang yung pipiliin mo. Hindi dalawa puso mo dito, bes. Iisa lang ang pipiliin mo. Iisa lang. Either you will ask for the specific performance or you will ask for the payment of the penalty. Yeah? So, ang exception dyan, gaya na sabi din kanina, that the penalty may be enforced is if after the creditor has decided to record the fulfillment, the same should become impossible without his fault. Meaning, sabi ni creditor kay debtor, debtor, sige, specific performance na lang. Tapos later on, nalaman nila na hindi na pala, impossible na pala magawa ni debtor yung specific performance, then he can afterwards demand for penalty na lang. Kasi hindi na pwede yung specific performance eh. So parang nagkaroon ng jump, parang binigyan mo ng chance, di ba? Binigyan mo ng chance si debtor na mag-specific performance pero hindi na pwedeng gawin. So, afterwards, after mong mag-demand ng specific performance, hindi nagawa yung performance kasi imposible na, then you can again demand for penalty. And if there was fraud on the part of the debtor, the creditor may recover the penalty as well as damages for the non-fulfillment. So, etc. Madali lang naman to penal clause. For me, in this discussion of part 2, mas mahirap, when it comes to complexity, I'm not saying mas mahirap, but when it comes to complexities, tawag ito, solidary obligation yan, solidary joint obligation. Ang second sa kanya is yung alternative. Ang third is yung divisible and indivisible. Itong obligation with the penal clause, madali lang to. Ngayon, proof of actual damages suffered by the 1228. Proof of actual damages suffered by the creditor is not necessary in order that the penalty may be demanded. Oo. Kasi nga, pagdating sa obligation to the penal clause, ang purpose mo dyan is, ayaw mo nang pagdaanan yung arduous, long, complex process, hard process of proving nagkaroon ng damages para you will now have the right to receive indemnity for damages and interest. Iniiwasan mo mangyari yon kasi mahaba ang proseso, mahirap yung proseso na patunayan mo may damages. So in this case, kaya nagkakaroon tayo ng obligations with the penal clause na kung saan, as long as there's a violation, as long as there's a breach, okay, bayad ng penalty. And yung pagbayad ng penalty is up to the amount of penalty lang. Kahit na yung later on, nalaman nyo yung damages was around 100k tapos yung penalty is 50k, di mo na pwedeng abulin yung additional 50k. Oo, up to yung 50k lang. Oo, kahit na mas mataas yung actual damages. Kasi ngayon yung point ng obligations with the penal clause. Padaliin yung proseso. Kaysa dumaan kayo sa mahabang proseso, mahaba at mahirap na proseso sa improving the damages, mahaba yan. Usually, pupunta pa yun sa korte yan kasi hindi kayo nagkakasando magkano yung actual damages na babayaran with the interest. So, instead na pagdaanan nyo pa yung proseso na yun, diretso na. Indemnity, 30,000. Okay, bayad. No, kahit na mas mataas yung actual damages, later na nalaman nyo, hindi na pwedeng habulin yung excess. Up to the penalty lang. Now, saan dito? Now, that is the general rule, di ba? Kasi sabi din kanina, the creditor may still recover damages on the 3 exceptions. Ano yun ulit? When it is stipulated by the parties, when the obligor refuses to pay the penalty, so papatungan na yun ng legal interest. And yung second, or yung third is yung when there is fraud. Yeah? General rule, the penalty substitutes the penalty substitutes the payment for damages and interest. That is the general rule. Anong exception? When it is stipulated with the parties, when the obligor refuses to pay the penalty, hence, papatungan na ng legal interest. And the third one is when there is fraud. And lastly, Article 1229, the judge shall equitably reduce the penalty when the principal obligation has been partly or irregularly complied with by the debtor. And the second one, even if there has been no performance, the penalty may also be reduced by the courts if it is iniquitous and or unconscionable. So, dalawang instances kung saan pwedeng mag-intervene yung korte when it comes to the amount of penalty. Una, kapag nagkaroon ng partial or irregular performance, so pwede nilang bawasan yung amount of penalty. Kasi, considering na at least may nagawa naman, di ba ganun? So, bawasan na lang. On the second part, kapag nagkaroon ng kung non-performance talaga, pero yung penalty na nilagay is iniquitous or unconscionable. Like for example, 1 million pesos a day for every time nagkakaroon ng violation. 1 million pesos a day for each day of violation. Na ikaw, that is iniquitous or unconscionable. Parang unreasonable, di ba? 1 million a day for each day of non-compliance na hindi mo ginagawa yung obligation mo. That is unreasonable. So, pwedeng bawasan niya ng korte. Sabi mo, file ka ng petition sa court, reduce mo yung amount of penalty. Kasi kawawa naman. That is unreasonable. So, dyan, pwede mag-intervene yung korte dyan. And lastly, the nullity of the penal clause does not carry with it of the principal obligation. The nullity of the principal obligation carries with it of the penal clause. So, ito ganito. Dalawang pinag-usapan dito. The principal and the accessory. Ngayon, ang rule, accessory follows the principal. Kasi 'di ba? The principal can stand on its own. The accessory cannot. Kasi ang accessory nakadepende sa principal. So the accessory follows the principal. It cannot be vice versa. So if the principal is void if the principal is void, then the penalty is, then the accessory, is also void. Kasi nga, di ba, the accessory is attached to the principal. It cannot stand on its own. Now, on the other hand, if the accessory is void while the principal is valid, ladies and gentlemen, then it is only the accessory that is void. Yun lang. Principal hindi siya damay because the principal can stand on its own. So, ulitin na natin. Principal is void, accessory hindi void. Principal is void, yung accessory hindi void. The entire obligation, boom, wala na yan. On the other hand, if the accessory is void, except for example, the penal clause, void yung penal clause mo, accessory man yan. But the principal is not, then accessory lang, matatanggal, the principal will remain valid. Okay. Ulitin natin. Principal void, it carries with it the accessory, void na rin yan. So in this case, pag yung principal is void, yung penal clause, void na rin. On the other hand, if yung penal clause lang, which is the accessory obligation, yun lang yung void, yung principal hindi madadamay si principal. The principal will remain, the accessory will be gone. So with that, we end our discussion for the remaining parts of chapter 3. So sa next meeting natin is chapter 4 na, the extinguishment, modes of extinguishment ng obligation. So, don't forget, long quiz natin sa Saturday. Saturday this week kasi Sunday man yun. Saturday this week. So, ang coverage from the beginning up to chapter 3. Law. Okay, with that, we end our lesson. Bye-bye. Gutom na rin ako. Love you.